All right, we're going to go ahead and get Marshall County Fiscal Court called to order. Be June 20th, 2017. Under guest, I just got off the phone with Mr. Lee. He cannot make it, so he's not going to be here today. We'll follow up some other date. Yesterday, I got a call from Jeff, and we've been trying to get Mr. Bergdahl here for some time. I heard your presentation at Calvert City Council and happened to be in town, so we went ahead and discussed to put him on the agenda. So he is here. If you remember, we had discussed the sexual orientated businesses as far as the ordinance that we have, and he is I guess you can say the specialist when it comes to that type of litigation. So I did hear your presentation, and it is a great presentation. So if you want to step up, do you have anything to say?
No, this is just the first step into, we enacted an ordinance with Scott's help years ago when we did it in conjunction with Calvert City, the City of Benton, and City of Hardin, so that all of our ordinances would mirror each other in case this issue arose. And this is it's been several years now, so it's time to update it. And this presentation is to present facts for the court to consider in enacting your updated ordinance. That's all.
Good morning, sir.
Thank you, Judge, members of the Fiscal Court. My name is Scott Berchtold. I'm glad to be here with you this morning. It's a beautiful day, and I hope not to drag us through the gutter too much at the outset of it, but this is a necessary topic, and I really do want to commend the Fiscal Court for staying out in front of this issue. This is really an issue where an ounce of prevention is worth a pound of cure. The first ounce of prevention was the ordinance that Jeff just referred to that the Fiscal Court adopted. I looked back at my records, it was 2002. Time flies when you're having fun, I guess. But that was 15 years ago. And definitely it's time for an update because of a number of intervening court decisions. In that time lapse, we've handled cases at the Kentucky Supreme Court for McCracken County, for Louisville, Jefferson County. We had a case at the Court of Appeals for Lexington, Fayette County. So this is an issue that's kind of constantly evolving in the courts. The industry is constantly changing their strategies, trying to exploit loopholes, trying to avoid regulation. Just last Friday, I was in Greenville County, South Carolina, representing the sheriff and the county in court there from a business that came in under the auspices of a restaurant that was going to do a rib joint, but all of a sudden they're running a strip club. And the question then becomes, do you have the ordinances in place to deal with that type of a situation, to deal with it? And so that's what I'm here to talk about this morning. I'll try to be brief, but at the same time, the purpose is to make a record for any enforcement of the ordinance that might need to happen later on. If there's ever a court challenge, this legislative record that we're laying today will be the predicate for the adoption of the ordinance that will go a long, long ways to helping to defend the ordinance's constitutionality in court should it ever be challenged. This is sort of like the situation where a doctor gives bad news and good news and says, well, you've got this disease. The bad news is it's got to be somewhere in your body. The good news is you can choose where to put it. It's one of those situations where the Supreme Court of the United States has said that a local government cannot outright ban sexually oriented businesses, but what you can do is you can strictly regulate the time, the place, and the manner of their operation. And our experience has been that with really strong regulations in place, a lot of adult businesses will come down the highway, they'll be looking for a place to set up shop, they'll be looking for a location where they can get a lease interest to open a business, but they're going to go to the county offices or they're going to go to the city offices and they're going to look at the ordinance and they're going to say, is this ordinance constitutionally sound, and is it a tough ordinance? And that's what you have before you today for consideration with this presentation, is a tough but constitutionally sound ordinance, because in many, if not most cases, that operator or would-be operator is going to look at a tough ordinance that's in place and say, you know what, I just move on down the road and go find another location that is sort of caught with its ordinances down, so to speak. And so what we're going to do today is go through the legislative predicate for these types of regulations. Next slide. The baseline of this area of law is a case called City of Renton versus Playtime Theaters. Renton's a small town outside of Seattle. At that time had about 30,000 people. It was a bedroom community, but it had these adult theaters open up, and they adopted an ordinance that regulated where they could go. And the Supreme Court of the United States, in upholding the ordinance, said it was okay for Renton, which had never had any sexually oriented businesses in their city, to rely on the findings of a study that was done in Seattle, even though Seattle was 20 times the size of the city of Renton. And the court said the First Amendment does not require a city, before they enact an ordinance like this, to conduct new studies or produce evidence independent of what's already been generated by other cities, so long as whatever evidence the city relies upon is, quote unquote, reasonably believed to be relevant to the problem that the city addresses. So that's what this presentation is about. The evidence that's before you on the CD-ROMs, you've each been given a CD-ROM. There's an index accompanying that CD-ROM that has a list of 43 different studies and secondary effects reports. Some of them are from Louisville, Kentucky. Some of them are from Metropolis, Illinois, from the case that we handled for the city of Metropolis, up the road a little bit on the other side of the river from Paducah. Some of them are from Los Angeles, some of them from Atlanta. But the thread, or the sort of the common denominator of these studies, is they show that adverse secondary effects come into play when one of these types of land uses locates in a community. And if you could go to the next slide, we'll summarize what those secondary effects are. There's basically 5 major categories. The first one is negative impacts on surrounding property. So these could be noise and things that impair the use and enjoyment of someone's property. It could be decreased property values because people aren't willing to pay as much for a residential home that's in close proximity to an adult bookstore or an adult cabaret, which is the legal term for a strip club. Number 2, personal and property crimes and the public safety risk that goes along with these. There's a study actually just recently published in a criminology journal out of Louisville that looked at data, crime data in Louisville, Jefferson County, and documented a much larger incidence of crime within 500 feet to 1,000 feet of these sexually oriented businesses. And basically what the data shows is the farther that you walk away from one of these point sources or one of these hotspots, the lower your likelihood of being victimized, being the victim of an armed robbery or of a mugging or something like that. The farther you walk away, it goes down. As you walk towards that address, that risk goes up. So those types of crimes are a predicate for these laws. Number 3, obviously, lewdness and public indecency, the types of illicit sexual behavior that's commonly associated with these establishments. In Louisville, they did a sting where they arrested 31 people at a series of establishments that were all owned by the same folks. Number 4, illicit drug use and trafficking. Number 5, litter, aesthetic impacts. There have been cases where the courts have said, look, these places cause traffic, they cause blighting problems. Up the road in not Metropolis, but north of Metropolis, when you get towards Effingham, Illinois, if you're going up through Effingham, we had a case where one of these establishments opened in a village off of Interstate 70, and the population of the village was 255 people. They never had a serious crime in the village's history, never had an armed robbery, for example. And this adult bookstore came in off the interstate, and within the first 16 months they were open, they had 2 armed robberies. Both of them were at the address of the adult bookstore, and one of them involved 4 guys wearing ski masks and carrying shotguns. So because they're close to the interstate, can get on and get off really easy. So there really is a criminogenic aspect to this. If we go to the next slide, we'll talk about the sources of these secondary effects information. And the CD that you have really contains all of these different kinds of sources. There's land use reports that have been done by planning agencies. There are crime impact reports that have been done by law enforcement agencies, judicial opinions. The courts in this area of law have said that cities and counties can rely upon the findings of adverse secondary effects that are recounted in judicial opinions. 4, there's a number of expert reports that are on this CD that talk about the criminology associated with adult uses or sexually oriented businesses. And then number 5, anecdotal data. This is where folks have come into meetings like this this one, where the community already had an adult use, and they testified about the problems, the litter, the noise, the shouting, just the lights, the types of vagrants that are attracted to hang around some of these establishments. So that type of information is relevant as well. And on the next slide, what it lays out is sort of something that's in the ordinance, and it basically lays out the legislative predicate. It basically says sexually oriented businesses as a category of commercial land uses are associated with a wide variety of adverse secondary effects, including the ones that we've just talked about. And then a key part of this is the last sentence on this slide, and that is alcohol consumption impairs judgment and lowers inhibitions, thereby increasing the risk of these adverse secondary effects. One of the key issues in our case for Louisville and Jefferson County that went to the Kentucky Supreme Court back in 2010 was the government, the city county government adopted, the Metro Council, I guess it was, adopted a rule in their ordinance that prohibited alcohol on the premises of sexually oriented businesses, not even BYOB. You can't serve it, you can't have it, you can't possess it, you can't consume it. And of course, all the businesses in Louisville challenged that law, and in a unanimous decision, the Kentucky Supreme Court upheld that regulation. That's a constitutionally sound regulation, and the reason it's constitutionally sound is that it's well documented that the presence of alcohol in these establishments, particularly, is kind of adding oil and fire and oil together. It has a combustible effect. It increases the types of adverse effects that are occurring. On the next slide, there's some cases that have talked about. The Louisville case is called Blue Movies Incorporated versus Louisville Jefferson County Metro Government. That's the 2010 citation at the top. The second case that's cited is one that we handled for McCracken County. There was a new Supreme Court decision in 2002, and in 2003, the Kentucky Court of Appeals, sort of following that new Supreme Court of the United States decision, issued a ruling that was adverse to McCracken County on their ordinance, on a prosecution of the ordinance. That's why it was against the Commonwealth of Kentucky. And we were able to work with Denton and Coiler up in Paducah and get that case granted review by the Kentucky Supreme Court, and we argued that, and the day before Thanksgiving 2006 they issued an excellent opinion reversing the Court of Appeals and upholding the McCracken County ordinance. The third case that I think is particularly relevant here is Restaurant Ventures versus Lexington Fayette Urban County Government. The types of licensing and hours of operation and conduct rules that are in this ordinance before you today are the kinds that were upheld in that case for Lexington Fayette County. On the next slide, there's a couple more cases. These are from the Supreme Court of the United States that go to the alcohol prohibition that exists in this draft ordinance. And the Supreme Court said it best, I think, back in 1981. And I wish they would have this much common sense in all of their decisions. But in this one, they said common sense indicates that any form of nudity coupled with alcohol in a public place begets undesirable behavior. And in the next case is a case that we are actually involved with the Flanagan's Enterprises party in some litigation, but in the 11th Circuit Court of Appeals, and that's a federal appellate court that sits in Atlanta, Georgia, and it is over Alabama, Florida, and Georgia cases. Here in Kentucky, of course, we have the 6th Circuit Court of Appeals that's over Kentucky, Michigan, Ohio, and Tennessee cases. But the 11th Circuit said something really helpful. They explained in the data from Atlanta, which is Fulton County, the increase in secondary effects, the prominence of strip clubs playing a role in contributing to crime in the neighborhood. Even the municipal court judge, actually the juvenile court judge, came in before the legislative body and talked about women being recruited into this industry and the illegal activities going on, and that was helpful in upholding their ordinance. On the next slide, there's a case that we handled for Daytona Beach where, again, they adopted a restrictive rule relative to alcohol, and the 11th Circuit said that the evidence that the city of Daytona Beach put on, which is very much like the evidence that's on the CD-ROM that we supplied for you today, was not adequately challenged by the plaintiffs. The plaintiffs failed to cast what the courts call direct doubt on the legislative predicate for the law. On the next slide, it talks about case that we handled for the Attorney General Missouri, Chris Koster, where this type of ordinance, believe it or not, was adopted statewide across the state of Missouri. A number of groups from St. Louis to Kansas City challenged the ordinance or challenged the statewide statute on constitutional grounds. And based in part upon an expert report that I've supplied for you on the CD-ROM from Dr. Richard McCleary talking about the criminogenic effects of these types of land uses, these types of businesses, the Supreme Court of Missouri unanimously upheld that law. On the next slide, we get into more local territory, a Sixth Circuit case, which is relevant here in Kentucky because all the federal cases end up at the Sixth Circuit in Cincinnati. But a Knox County ordinance that we had done, which is where the University of Tennessee is up in Knoxville, they had adopted similar alcohol prohibition. The court said this: that prohibition is a reasonable restriction narrowly tailored to limit the secondary effects of crime. The county reasonably relied on a number of prior judicial decisions, finding sufficient evidence to support the connection between adverse effects and adult entertainment when combined with alcohol consumption. And then on the following slide, we also talk about what this ordinance does. From a structural standpoint, anybody who would seek to locate one of these businesses in the county would have to obtain a license. They'd have to go through a background check. They would have to be verified as someone that hasn't been convicted of certain crimes in the previous 5 to 10 years. And there's a number of cases from the Supreme Court down that uphold those types of licensing requirements. The structure of those licensing requirements are like the ones that were upheld in this Peekaboo versus Manatee County ordinance that we did that was upheld by the 11th Circuit in 2011. On the next slide, you'll see some other cases. Some of the recent trends in this industry have been for these businesses to come in and say, we're going to get a business license, we're going to be a gift shop, we're going to be a retail store, that's all we're going to be. We're not going to have an entertainment on the premises, we're not going to have movies showing, we're not going to have live entertainment, so we're just going to get this retail thing and then come in and they basically are running an adult bookstore. And what the industry has done has been met with a response by local governments to adapt and update their ordinances so they cover businesses that aren't convenience stores that have a couple magazines backed by the cigarettes, but rather are adult-related, sexually oriented stores. And so those types of ordinances have been challenged, and again, they've been upheld by the Sixth Circuit in some of the cases we've been involved with. The studies on your list, there's a 43-point list on your index there of what's on the studies. These are just some of them, but what I want you to see from looking at these slides is just to see that they cover the wide gamut of adverse secondary effects: blight, crime, surrounding properties, illicit sexual behavior, prostitution, drugs, those types of things. On the next slide, there's some more studies from Memphis, from Fulton County, Georgia, some of the stuff that we have from Metropolis, Illinois, investigator affidavits. Some of you may remember a couple of years ago when that establishment was open near the Casino Riverboat on the other side of the river from Paducah, and they came in and said we're going to run a clean operation and so on and so forth. But that's not what the police investigation and the private investigation showed. Ultimately, when they challenged the ordinance that Metropolis had adopted, which, like this one, prohibited alcohol, we were in the federal court in Benton, Illinois, up the road a little bit. The federal court upheld that ordinance, and then with some enforcement of that ordinance, that establishment decided that it really could not make a go of it in Metropolis, operating under the constitutionally sound restrictions that were in place. And then on the next slide, just a little bit about experts. I won't go long on this, but in a lot of cases, they will hire some expert, some PhD, some land use planner to come in and say, oh, all these studies are flawed in one way or another. They're not sufficiently scientific. They didn't use multivariate regression analysis or something silly. But essentially, the courts have rejected these industry challenges on the grounds that a local government doesn't have to have a PhD come in and tell them what is sound public policy in regulating these types of establishments. As long as there is a adequate factual predicate basis, like what we've been talking about this morning, like what's on the CD-ROM, the courts say that a government entity, such as a fiscal court or a city council, can rely on any evidence reasonably believed to be relevant. That's a low threshold that's easily met. And in a number of cases, they've actually come back and said the industry studies, the counter studies, as you might call them, to attack the ordinances and the predicate upon which they're based, are flawed in a number of ways to adequately explain and to account for the crimes that have been documented at these establishments. On the next slide, there's just a little note here that what we'll do is see a number of cases. If we ever had that situation arise, we would know who to hire, we would know how to defend those ordinances, know how to defend this legislative predicate against challenge. And on the next slide, there's a couple of cases in which we've done that. One of them is the High Five Investments case in Georgia, in more of a rural county, Floyd County, Georgia. It's in Rome. It's probably an hour to an hour and a half outside of Atlanta, where a retail adult store came in and tried to challenge and attack their ordinances and hired an expert and so on and so forth, but those were ultimately unsuccessful attacks. And then on the next slide, what I want to make clear is just that all this documentation, a copy of it has been provided to the fiscal court clerk so that it can be a part of the minutes for this meeting. So if, hopefully not, but if some point 5, 7, 6, 8, 9 years down the road, someone comes in and challenges the ordinance, we can go back to the minutes, we can pull this data, and that will be our first filing in the court. And in fact, what we have done in a number of cases is taken the certification of a clerk and the legislative record documentation, and on the day that we file the answer, we would actually, to the lawsuit, we would actually file a motion for judgment on the pleadings on the entire case, saying there's no need for any discovery, there's no need for depositions, there's no need for this, we're going to get this resolved right away. And in the Missouri Supreme Court case and in multiple Georgia Supreme Court cases, we've had big pre-existing strip clubs with hundreds of employees sometimes come in and file those types of lawsuits, sometimes 15 counts. And we've had the courts, by God's grace, grant judgment on the pleadings and dispose of the entire case on the city's first filing, basically. So it's something that if you have a strong law, which Marshall County will have upon the adoption of this ordinance, it's something that if there is a challenge, the goal would be to terminate that challenge at the earliest possible juncture under the local court's rules. And with that, I'd be glad to address any questions. Thank you. I know it's a long presentation. We want to make the record clear, but I'd be glad to address any questions that anyone may have.
Anybody have any questions?
What is the county not having planning and zoning, does that hamper this in any way?
Well, it may have some implications on location requirements, but with regard to this ordinance, which is a licensing and regulatory ordinance, and the prohibition on operating past 12 midnight, the prohibition on having alcohol on the premises, the prohibition on dancers having to get licenses and go through background checks, it doesn't have any implications there. These are all ones that I'm confident that the county has state law authority to adopt.
Obviously, the content has changed from 12 years ago simply because Marshall County is wet now. And
Right.
That gives us more teeth, apparently, from
That's right.
my understanding.
That's right. Since the referendum election and going wet, this allows the county to have an exception to where alcohol would be served or consumed, and it's a constitutional exception that's akin to what the Georgia or the Kentucky Supreme Court upheld in 2010 in the Louisville case.
What's a good rule of thumb to review documents like this for
You know what? I would do two
municipalities?
things. When you open up the CD-ROM, the first document is the index, and the second document is a summary. Well, actually, the second document is all the cases that are cited in the document. And I'm going to leave copies of the draft ordinance with everybody, but I'll leave those with Jeff for distribution. But The third document, actually, the third PDF is called Summaries, and it's about a 12 to 15 page document that takes a number of the summaries that are in full on the disc and gives about a 2-paragraph abstract that helps you know what the essence or the holding, as a lawyer would say, of that study is. What did that study ultimately conclude after looking at the data in Indianapolis, for example? And then that, I think that one's a really good one to review. And then if you want to review in more detail sort of the study from Louisville, because it's fairly local. If you want to look at the police investigator affidavits from Metropolis, those are on the CD as well. But I would start with those summaries.
I noticed a few things on there that you could probably implement into that is with the spreading of the STDs, drug abuse, the drugs on the market, synthetic opiates and all
Right.
that. That creates, right out of the get-go, a hazmat scene where that takes place. So, I mean, this also is a hazardous material.
Piece
Problem.
of it. Yeah, that's right. I mean, that's a problem in a lot of rural counties and a lot of urban cities, K2, other types of synthetic drugs. Obviously, now things being mixed with fentanyl and becoming very, very serious very, very quickly. That's really a travesty. But this is something that if anybody was convicted of a drug-related crime, if they were convicted of, let's say, promoting prostitution in Indiana or in Missouri or in Louisville, and that came up on their record, then they would be automatically disqualified from getting a license, because that's precisely the type of negative secondary effects and crime-related activity that the county's trying to prevent.
Scott, have you seen anything? I know we talk about the drugs and the alcohol, but what about human trafficking? I know that there's been a lot of increase with human trafficking. Has there been anything tied to what you see in these cases?
Oh, yes, absolutely. We are currently representing the Attorney General of Louisiana in a case. My brief is due on July 18th before the U.S. Court of Appeals for the Fifth Circuit in New Orleans. And that was a law that the Louisiana legislature adopted to prohibit 18, 19, and 20-year-olds from working as dancers in these establishments because of a 19-year-old dancer that was recruited. Her pimp basically had her working at one of these clubs on Bourbon Street and then ended up murdering her. And that case, her name is Josilas Wright, that ended up triggering a whole bunch of legislation both in the city of New Orleans and in the state. But we've done, in the last year, we did human trafficking training for the International Municipal Lawyers Association at their annual conference back in San Diego in October. I did a panel presentation with the Polaris Project. And Polaris Project are the folks that run the human trafficking hotline nationwide for the DOJ. So there's been a number of cases. In fact, I have a separate PowerPoint presentation on my laptop right here that I could put up and take the next half an hour and just show you case after case after case where there's been trafficking involved in strip clubs. I have a case right now on appeal to the Sixth Circuit. I'm waiting for a decision out of Warren, Michigan. That's a suburb of Detroit. And the guy that's suing us had a club in, I say us, suing the city of Warren, Michigan, had a club on 8 Mile Road in Detroit, and there's a lawsuit pending against him because 2 women were brought over from the Ukraine under false pretenses that they were going to be nannies or they're going to be maids, and eventually what happened was their documents were taken from them, they were held against their will, they were forced to strip at a place called Cheetahs on 8 Mile for 16 hours a day, and the federal government eventually got involved. One guy was convicted and sentenced to prison. The other guy was convicted in absentia, and they're trying to basically retrieve him from Russia. So this is not an uncommon occurrence. It only makes sense that human traffickers are going to go to a place where they perceive that vulnerable young people are available to be duped, to be coerced, to be drugged into this profession. And then on the flip side, they will go and not only try to use, sell their women at these clubs in the VIP rooms for other services and so forth. But what they'll do is they'll go and try to recruit there. And so that was happening in Canton, Ohio recently when a guy was convicted and sentenced to 4 years in prison, which I think is piddly. But nevertheless, these cases in adult entertainment industry operations have been documented time and again. Yep. And so one of the things that this ordinance does when you're looking at the draft of it, there's a background check situation where you get the information on these people and you can run E-Verify on them. You can make sure they're in the country legally. There's some options. They're not all spelled out in the ordinance because we want the law enforcement agencies in the jurisdiction to have flexibility to use whatever tools that they can have at their disposal. But the ordinance definitely does help to prevent that. And one of the things is this has an inspection provision in it. It says that the county judge executive or his designee, which could be the sheriff or could be a code enforcement officer, can go into these places anytime that they're open for business and can have access to any portion of the premises to which any patron has access. Couldn't go back into their file room and start, getting on their computer or rifling through paper files, but a warrantless administrative inspection has been upheld where it's unannounced and it's limited to the hours that the business is open, and it's limited to the portion of the premises where any patron can go, but that includes back rooms, booths, VIPs. And so the regulatory authority in this ordinance for doing inspections is another thing that deters human trafficking because those folks know that law enforcement can show up at any time. And another thing, frankly, the 6-foot rule, there's another provision in this ordinance that has a 6-foot separation requirement between people who are dancers essentially and those that are patrons. And someone can come in, code enforcement, law enforcement, they can do a visual survey of the room, and just by standing at the front door essentially or inside the main room, they can see if there's a 6-foot separation. But if there's any type of physical contact, those types of restrictions have been upheld by the Kentucky Court of Appeals and the Kentucky Supreme Court. And once you, that's why I say that someone that comes to town and says, let me see the Marshall County ordinance on these things, once they start looking at these restrictions, they're going to think twice about whether that's a rubric under which they can do their business. Because we've done ordinances, we've probably done 300 ordinances in 25 states. And these ordinances are tough, they're constitutionally sound, they prevent the secondary effects. And my experience is businesses either violate them and face the consequences of what happened up in Metropolis, or they just move on. So,
Thank you.
any other questions? I'd be glad to address them. Thank you very much for your attention this morning. This is an important topic. And again, I commend you for getting out on the front end of this, not waiting until something happens. I commend Jeff for getting in contact with us, making sure that we're out ahead of the curve. And I think that's what this ordinance will do.
Appreciate it. Thank you, Scott.
Okay.
Thank you, Scott.
Yes. Yes. Yeah.
All right. We're going to move on to guest. Mr. Lee's not here, so Zach Bryan. That's going to discuss the road name change that was requested.
morning,
I think.
Judge.
Good morning. I think it was, there was a petition that was submitted in 2013 that was tabled
Yes,
for
sir.
the road name. Okay.
That's correct. My understanding of that was it was tabled to get signatures of all the landowners on of the tracks on Lookout Lane. I have those for you today, and the members of the court. If I may present those.
Thank you.
And Judge, I'm here with and on behalf of Mr. Ron Bashirs this morning, again petitioning the court to change the name of Lookout Lane to Bashirs Lane. There is an S on the end of that. I want to make sure that we get the spelling correctly. Again, just as a way of a little bit of background here, this petition was presented in 2013. It was tabled by the court pending written approval of all the landowners there. Mr. Bashirs has since received the signatures of all the landowners on Lookout Lane, all the landowners on Yucca Lane, which isn't required, but we just thought it would be good practice and best practice to do that because Yucca Lane does Y off from Lookout Lane. And then this road comes off of Sled Creek Drive, and there are two lots on the corner of Sled Creek Drive which abut Sled Creek and have Sled Creek addresses, but their signatures are also included in that. So, in other words, everybody on the road, everybody who's near the road or basically can look at the road has signed off on the change to this. So we'd again request that the road be changed in honor of Mr. Bashirs' father. This would be his 100th year of life, and Mr. Bashirs is requesting that Lookout Lane be changed to Bashirs Lane in his honor this year.
I think in y'all's packet, you were given the petition from 2013 and the minutes as far as when it was tabled. There was discussion, but there wasn't any action from the fiscal court. So Mr. Bryan, with his client, is here today to ask the court to take action. So I think we need to, you've got the material, you've seen it. Is there any questions before we move forward?
I just wanted to be sure, at the time, I know we had landowners that opposed this change, and so we have all the landowners that touch the road or would be involved. If they're signed off on it, I certainly wouldn't oppose.
Yeah, I mean, as an overview, this matter was filed as required by the ordinance in April of that odd year, and it was in fact officially tabled. It wasn't, no action taken, so it's been pending ever since. There was one landowner who had an objection. That property is transferred, and like he said, there's I've reviewed the signature list and the map, and every property that adjoins that road and the secondary road to it have all signed off on it. So it does appear to me to be in order and fully complies, more than complies with your county ordinance.
Zach, who was the landowner that objected, not last time, but the new landowner there? Is his signature, which signatures?
Yes, sir. That would be,
Kevin Diamond?
No. That objected?
no.
No, I know who objected, but who is the property owner now? Ron?
Philip Higdon?
Mr. Higdon's signature's on there, Philip Higdon.
Okay, so that's the one that's on there.
Yeah, he's on the corner of currently Lookout Lane and Yucca Lane there in lot 78.
Right, okay, signatures, it's number 7, okay.
Yes.
Yeah, I agree with Bob, that was the only objection last time, and you all have gone beyond the call of duty with Slade Creek residents, which is making it good and clean, but I have no problem with the name.
I know this has been important to Mr. Bashirs, and he's done a lot of legwork to get the consensus out there, and we believe we've got it today.
And Bob, I think you mentioned some time ago that there had been a policy or a part of our ordinance that had been discussed about naming roads after living persons. With the judge's help, we've located that document, and it's not an official document. There's just a document that was stuck in the file that said roads shouldn't be named after living persons. Now, obviously, over the years, there have been several roads in this county named after living persons, but that provision that was on that document has no legal effect on you all whatsoever.
Motion to approve the road change.
Is there a second?
Second.
All those in favor say aye. Any opposed? Motion carries.
Thank you very much,
Thank you,
Judge.
sir.
Commissioners.
We'll move on to correspondence. The Lake News Mayor Bration ad. You should have a copy of the ad. Let's see, you can do a half a page for $429.66, quarter page $214.83, and an eighth page. What did we do last year? Do we know, Emily?
Did a half
We do a
page.
Did a half page.
I think that's right.
And then I think we got, replaced that with the county's logo.
Lord says we did a full page.
We did a full. The ad, I think, is everybody fine with the actual ad from last year? And if so, I think the logo is the only thing that we would ask to change. Okay. So do y'all want to do the same half-page ad.
I move that
sorry,
we,
full-
I move that
full
we do a
page.
full page, the Mary Bracey Calvert City attracts tens of thousands of people, 10,000 people, Lloyd. He's not paying attention, about 10,000 people.
Second. All those in favor say aye.
Aye.
Any opposed? Motion carries.
Before you go on, can I back up on the Brashear Lane? Is that, no other reading, it is officially changed at this point?
Yes.
Okay, well,
Yeah.
we need to notify GIS and get all that changed for emergency responder purposes, because that could be hectic at times, yeah.
Yeah.
Yeah, Wendy.
Let's see, old business, approve the minutes for June 2nd budget workshop and June 19th budget workshop.
Motion to approve the minutes, Judge.
Second.
All those in favor say aye. Any opposed? Motion carries. Move on to ordinance 2017-02, the budget for fiscal year 17-18 be the second reading. Read that.
Ordinance relating to the annual budget and appropriations be it ordained by the fiscal court of Marshall County, Kentucky. Section 1, the following budget is adopted for the fiscal year 17-18, and the amounts stated are as appropriated for the purposes indicated. Budget of Marshall County, fiscal year ending June 30th, 2018. This is a summary of appropriations. General fund, your general government is $6,918,627. 5,100 is protection to persons and property, which is $504,925. 5,200, general health and sanitation is $247,400. 5,300 is social services. And is $213,200. 5,400, recreation and culture, $915,100. Debt service, $42,445. Capital projects, $285,000. General services, $395,500. Reserves, $3,045,428. Fringe benefits, $412,000, for a total general fund budget of $12,979,625. Road fund, 6,100. Roads is $2,928,259. General services is $5,500. Reserves is $675,000. Fringe benefits is $335,500. Road fund, $4,144,259. Jail fund, protections to persons and property, $1,584,150. Reserves, $60,900. Fringe benefits, $699,700, for a total jail fund budget of $2,344,000 and $2,344,750. Grant fund, 0. 911 fund, protection to persons and property, is $491,600. Reserves, $52,900. Fringe benefits, $190,700. Occupational tax administrator, general government, $120,000, for a total budget of $120,000. Veterans van, 0. ABC fund is, your administration is $89,910. Policing and enforcement, $214,400. Reserves, $12,600. Fringe benefits, $28,200, for a total fund of $345,110. Building inspection fund, $238,400. Reserves, $13,400. Fringe benefits, $18,300, for a total building inspection fund of $270,100. Your total budget for fiscal year 18 is $20,939,044. Section 2, this ordinance shall be published in the Tribune Courier newspaper by title and summary within 30 days following adoption. This ordinance becomes effective upon passage and publication, and all interested persons and organizations in Marshall County are hereby notified that a copy of the county's proposed budget is in full is available for public inspection at the office of the county judge executive during normal business hours. There is one change on there since yesterday. This had to do with the park and the road department and when we were able to finish a project with the box culvert. I've moved $2,500 out of general fund reserve into the parks construction account in the event that that is not able to take place this fiscal year. He has budget for it next fiscal year.
Any questions on that? All right. It requires a second reading, and that's the second reading, so we need a vote, a motion to approve the fiscal year 17-18 budget.
Okay, motion, Judge.
Second. All those in favor say aye.
Aye.
Any opposed? Motion carries. I think it's important to point out, because these documents are uploaded to the webpage and probably put out to the public, but I think it's important when they see the numbers like zero out beside the Veterans Van Fund. One of the things that we did is we did a grant application for nonprofit organization. The Veterans Van Fund is actually funded, but it's going to be managed by a different organization, not the fiscal court. So I know some people may see those zeros and think that there's nothing being funded, but they are being funded.
I do have one more action that would be related to the budget. It's to set our standing order for salaries and utilities. You all should have a copy of this in your information. It just lists all of our payroll and fringe line items, travel, I think even the uniform line item. This just allows my office to go ahead and make payroll, pay utility bills, pay for uniforms, things like that, that can come through your approval after the fact. It's an annual order stating to approve certain recurring expenses pursuant to KRS 68.2753. The fiscal court may adopt an order to pre-approve the payment of monthly payroll and utility expenses. No other expenses shall be pre-approved pursuant to this subsection without the written consent of the state and local finance officer. The fiscal court of Marshall County further orders upon the written consent of the state and local finance officer, the following expenses be paid when due. And it has all these line items listed. It is hereby acknowledged that the above standing order shall expire after July 1 of each fiscal year, and no more payments designated in the standing order shall be pre-approved unless a new order is adopted by the fiscal court of Marshall County, according to provisions KRS 68.2753.
Find it? It's on the
Apparently in the back of new
last page,
business.
new business.
Okay.
Around, Emily.
Oh, I'm sorry, I didn't realize she stuck it on there in another place. Sorry.
Same issue we do every year. Motion to approve the standing order.
Second.
All those in favor say aye. Any opposed? Motion carries. Under old business, ordinance 2017-05, administrative code. We've done the first reading. We need the second reading. Brad, do you want to do the second reading? Or Jeff, whoever.
Okay, I'm sorry.
I just haven't attached too many pages. I
Okay.
can pull the whole thing up if you want.
No. Under, the one amendment that was discussed is under section 5.3, under exempt employee, those who are not granted the protection of fair labor standards at the LSA and are not entitled to overtime pay or pay for compensatory time earned, compensatory Story time shall have no cap, but will have no monetary value upon employment separation. That's the definition of exempt employee. Under 5.2, the new number 6, employees who have specific exceptions set out in the terms of their employment. And under 5.24 sick leave, number C, unused sick leave will carry over from year to year without a maximum limit. Because it's paid sick time is to be used for medical reasons, no compensation will be received for unused sick time upon termination, resignation, retirement, or change in status from full-time to part-time. Under G part, same section, the sick leave, an employee may donate sick time to be used by a co-employee for sick time if all vacation and sick time have been used by the co-employee. For an employee to donate vacation time for a co-employee to use as sick time, a written request must be submitted to the Human Resource Director, approved and delivered by the department head or the appointing authority. Under 5.32A, county pays non-exempt and exempt employees earning less than $913 per week or $47,476 per year, time and a half, 1.5, for all hours earned over 40 hours in a work week. Earned paid leave shall not be considered earned hours in relation to overtime pay, but holiday does count towards overtime. All overtime shall be approved by the department head or appointing authority. Section B, under county vehicles, the drug-free is now hyphen-free in that case. And then under section 5.51, the subsection 3 mileage has been eliminated. Replacement proposed language is travel. The county offers a corporate rental program through enterprise and county-owned vehicles for travel. These methods are preferred. Department heads and/or appointing authority may offer to pay mileage at the federal government rate to use a vehicle if it is deemed more cost-effective. The department head and/or appointing authority may also reimburse the county an amount equal to a vehicle rental if the employee still chooses to travel in his or her personal vehicle. And I have the one other, I forwarded a proposed addition from Commissioner Koch to that in an email. You have that.
I think with the amendments, Jeff, pertaining to the second reading, I guess you just did the second reading, but the amendments, we can go down each one and vote, because I know that there's some questions
You can
pertaining
vote
to each
on them in
one.
total or in individual.
Yeah, I think it'd be individual, because if you do it in total, there may be one that
Right.
is accepted, but
Yeah, that's what this one is. Under that, the alternate, well, it was suggested or proposed that, that last paragraph I read, that this sentence be included. Alternatively, the employee may drive his or her own vehicle and receive mileage at the federal rate for the miles traveled. Now, obviously, if that would be the one that you all would want to address individually, because there's either that language would be included or not be included.
well, I think my question is that the actual amendment as it's presented actually takes in consideration what was discussed in open court. Based off of the statute, what does that change as far, when you present the amendment, you present it in full? So the amendments have been presented in full, and what was discussed in open court is actually in the amendment.
Right.
So
And well,
what's
you can, in any ordinance, in the first and second reading, you can make modifications as, because at this point, you're gonna, before it was suggested modifications, if you vote and approve a specific modification now or amendment, then that would have the effect now.
Well, I think my question is when you look at the statute 67076, county ordinance shall be amended by ordinance and only by setting out in full each amended section. Now, we set out in full what was discussed in open meetings, and that amendment fits the statute. The email that you're talking about with a one-line sentence as far as a change is not, my question is, it doesn't appear that it meets the statute as far as amendment.
Well, I think what's required by the statute is it isn't, by, the specific language has been identified and is presented as a proposed amendment during this period that this code can be amended.
Would
I
we
mean, I think
not, would we not vote on the presented amendment, which has been presented in full by the statute? I mean, it has, what was discussed in court, it actually has the federal rate in the amendment.
Right. But that can be amended as well at this time through this process.
Yes, we discussed that ordinance in the budget workshop, one of our budget workshops, and the language was, I asked that the language be added to this document.
Budget
Maybe
workshop,
missing
there
the
was,
question.
as far as this statute where it states county ordinance, this is an ordinance, we're doing a second reading, shall be amended by ordinance and only by setting out in full each amended.
Yeah.
Well, that's just a sentence.
I know, all of these are just, are partial. That's referring to, once it's been enacted and amending it. And I think that these proposed amendments that we've just reviewed during this month, where this ordinance can be amended, I don't see I mean, I think we're going through the official process to consider amendments.
Well, like for an example, and maybe I'm looking at this wrong, but as far as the statute says, in full, we presented the actual amendment to this section, 5.2 in full. I mean, here's the entire reading of the amendment for the administrative code. My question is, you got a one-line, and actually that one-line sentence is outside of what was discussed in open court, which we put into the amendment. So I think we need to vote on what was presented.
And then vote to amend it.
Well, I mean, it's, when you vote for these amendments, it's just a vote.
Yeah. I mean, I think if you vote, just that, on that particular, there's been a proposed amendment to that. You can vote to whether that's going to be added or not, and then whether or not the entire thing's going to be adopted. So you're amending, what this is an addition to, this is a proposed amendment to that section, just adding on the last sentence, and that's the reason I spelled out section 1.3 A, and then the three periods, and then that additional language as that showing that that is a part in full of that section.
Right, but where in that section does that sentence go?
Right at the end?
At the end.
Yeah. That's the reason I put the three dots there, was that it's A, then the body is there, then that addition to it. That was my intent. Now, that might not have been 100% grammatically correct, but I think it is.
Okay. All right, I just want to make sure that we're following the statute, because a amendment has been presented in full.
Yes.
And no action has been taken.
Right.
If there's any amendments to the amendment, does that have to be written in full?
Yes, and I believe it, but my intent was that includes the language that's already there, but shows the additional language. That, rather than write the whole thing out, I think that is in full.
Okay, that's, I want to make sure that we're not changing.
I agree. And that amendment would be considered to be amending the amendment before, and then whether or not you adopt the whole thing.
And that
all
has to
takes
be
place-
voted on.
Oh, yes.
That all
Okay.
takes place between the first and the second reading. It's my understanding that between the first and the second reading, when this document was presented to us, this was the administration's changes, and it was read without any discussion. And then between the first and second reading, which this is the second reading, we had multiple discussions in budget workshops concerning that language and so forth, and that's when I requested that
If
you
If you all
draft that.
recall at the meeting, at the first reading, you brought this up, and I asked to, stated I would need the full language contained in and what you were proposing, and you proposed that it be the same language as you had discussed some time back. That's when the other day, you and I met, and I pull that, and I think, and I put this on the end in a way that I think reflects what you've requested and will match the language in the amendment.
What does it say again?
Yeah, well, that's,
Jeff, do you have the language that was proposed the first time?
I've got it right here.
Yep, I've had that printed.
This was the admin code. This was the first language, 5.51, Section 3. Replace it with, and this is quoted, if travel was required outside the county, the employee representing the county and traveling on the county's behalf may choose either the federal rate or the substitute vehicle. This is the email that was presented, I guess, this week, which is going back to what I guess was originally requested. It's a little bit different. Alternatively, the employee may drive his or her own vehicle and receive mileage at the federal rate for miles traveled.
Yes, I asked in our meeting that language be the exact language because it was approved by the legal counsel after we mentioned it a couple of months ago.
I mean, those are the, and that's where I think the statute, and the way I read the statute, is so that you have it in writing, amendments. There's been 5 amendments that have been presented in full. Now, if you want to discuss changing the amendments, I mean, obviously, that's when it pertains to the administrative code, that's in the month of June, and that can be done, but there's been obviously some different changes to what's actually being asked to be amended.
Well, and I think that that can be done between the first and second readings.
Absolutely.
Yes, and I just want to make sure that because I know it's confusing, I want to make sure that all the commissioners understand what, and this pertains to the travel, what is actually being asked to be amended. And there's an amendment, and now there's language to amend the amendment. So, does everybody understand that? Okay. Now, we're going to move on with the amendments. We'll do it by vote. We'll just go down each amendment. And I think the best way to do it is when we get to that amendment, we discuss amending it, and we vote on it. Right?
Yes, sir.
Okay.
I'm still a little confused, but in between the first and the second reading, my intention was upon the second reading that language be in the second reading.
It has been. That's the reason I read it.
Okay.
And that's the question. Your language is actually with the federal rate is in the amendment.
Well, it's a proposed amendment to the proposed language, or original proposed language. And I think that it's the court's discretion to make proposals or amendments in getting the final language that that you want.
Exactly, and it's a full court decision, it's four people's vote on the documentation, and what was presented to us was just the administration's suggestions for changes, and after discussion, and it was read in the first reading with no discussion, and then in between the first and second reading, my understanding, the law allows us to change or tweak before the second reading, and in budget workshop, when I asked that language to be put in there, as I stated, and the judge just read, as of a couple of months ago, I asked that language to be added to this document for the second reading.
When you all get to that point, your motion, whether someone will make a motion to approve what the final language should be,
Correct,
and there'll have to be a vote on the final language.
correct. You want to go down the First Amendment? Exempt employee.
I don't think that's in our packet, is it, Des? This, I've got mine from previous meetings.
It's up on the,
Yeah, I was looking for it.
I didn't have the package in mind.
these are the amendments that were presented.
Last one.
Voting on this one right here. Motion to approve.
Is there a second?
Second?
All those in favor say aye.
Aye.
Any opposed? Motion carries. Next one is scope of coverage, section 5.2.
To approve?
Second.
All those in favor say aye. Any opposed? Motion carries. Next section should be sick leave, 5.24.
Motion to approve? The commas?
Second. Second. All those in favor say aye. Any opposed? Motion carries. Next one should be section county vehicles, 5.33. No, wait a minute, 5.32, overtime compensation time.
5.23,
The sick leave was, yeah, 5.24, and there were two changes, G and C. Yeah, so now we're at 5.32, overtime and compensation time. Five 5.32.
I've got a question on that. And when we address this, the change towards that 40-hour week includes holidays, does count towards the overtime, but sick time and earned vacation time does not. Is that the? Correct. It's my feeling that our employee we choose as a court to allow holidays to be used, but we don't choose to honor the earned sick time and vacation time.
Correct.
And I just think sick time, vacation time, and holiday is comparing apples to apples. I can't differentiate between the three. And my problem with this, and it didn't happen so much this last go-around because we had a mild winter, but if our road department 4 employees take off Monday and Tuesday, or take a vacation day, and they work Wednesday, Thursday, and Friday at noon, it starts pounding snow, and by 3 o'clock, 3:30, time to go home, they, Roy and Wendy decide that we're gonna have to start pushing 12 inches of snow and get ahead of the game. Those people that took a vacation day on Monday and Tuesday are not going to be, they're going to be working for straight time, where the people that working beside them are going to be working for time and a half. Is that correct?
If they were kept over, you mean it's not a
No.
call out, right? Just kept over?
Just kept over.
Correct.
Okay. Like I say,
I don't agree with the vacation time either. Vacation is just like you work, as far as I'm concerned.
Or the sick
No,
time.
And the
Or
sick
Or the sick
time
time is
also.
too.
The thing that we introduced was the call-out for those 3 departments to make up for that.
Right.
It won't always be call-out.
I think they're talking
Well,
about if it
We're
doesn't,
not
if they
talking
just
about
get
the
held
call-out.
over.
The call-out's good policy. I agree with that call-out policy.
But the call-out was presented because of, sitting down with like Wendy. One of the problems she had is she had people that weren't going to go out when they got called out and work straight time. So we put
Nor are people, in my opinion,
the
nor are people
call-out
in this
time
other
in place.
situation.
I think the question is that, we've had this for a year, we've looked at the numbers, and looking at how it's been in place for a year with the call-out, there's been more overtime with call-out than there has been for, during the week if someone does take a vacation or is off sick. So we were trying to look at what is the best option for the taxpayer as far as the dollars, the employees getting paid, the call-out. We've got, I pulled some numbers just to show. Brad, you might be able to pull it up, but there's with the call-out policy that was in place, there's actually, it kind of did what we wanted to do for those employees that were getting called out. They were getting paid and compensated as such.
I don't think anybody has a problem with the call-out policy. We're talking about totally something different here.
Well, I understand that, but it has a dollar effect to what we're talking about.
We agree.
The call-out was put in place because the administrative code didn't have anything, I think, at the time.
First,
The first one. And
everything
so
counted.
we put that in place, and it took care of that problem. But if you change it, there's going to be a dollar effect to it, and without looking at the numbers to see that, we can discuss if there's an adverse effect to an employee, well, we got to look at the numbers to see if anybody's been adversely affected. And putting that call-out policy in place, obviously, no one's going to come out and work straight time after hours. We identified that, and that's why we, as a court, put that in place for a 4-hour minimum call-out. If you change and you don't address the 4-hour minimum call-out, there are dollars attached to that. And there is an adverse effect to that decision if we don't discuss that, because it is tied together. That make any sense?
I think you're
See what I'm saying?
penalizing, though, an
And if-
employee for, you're penalizing him for not getting his time and a half just because he took a sick day. If he gets
or a
called out.
Or a
vacation day.
vacation day.
And
Yeah,
that's as earned as, this body decides what holidays our employees get. We don't have to give our employees any holidays. We don't have to give our employees any vacation, nor do we have to have a sick leave policy and give them sick days.
Right.
No, I'm absolutely not. I mean, but I'm comparing apples to apples. I see it with the change being made here. It's not on the screen now, but it says holidays do count towards overtime, and vacation and sick time don't. As
What?
far as that.
Yeah.
And if it snows 12 inches, and I expect those employees to be answer the bell, which they always do, and thus they need to be compensated, in my opinion, for that time. They don't, just because they took I think vacation day or a sick day is an earned day by some formula that this body has adopted, as well as is a holiday. And I think if you take apples to apples, I think all three of them needed to be. It's going to be hard to get a guy to go out there, but I fully expect an employee, or I would be looking for another employee if they didn't answer the bell with 12 inches of snow on the ground, and they always have.
Well,
But I think we need to be fair to them.
Let's make sure that before we make decisions, we understand what we're making decisions about. And I understand the contents of the conversation, but I don't think we're looking at the numbers. Not all the employees, and we'll use the road department, or even, you've got the three departments that do the call out, the road department, techs, crew, and the animal shelter. But not all the employees are on the call-out list. The men are asked if they want to sign up. When you look at the overtime this past fiscal year that we've been working under, we sat down with the superintendent from the road department, and that was a concern that she had, that there was nothing in place that those employees were going to be paid time and a half. So we put in place those call-out policies so that if they got called out after hours, they got paid. And the minimum was 4 hours.
And that is a good
And
policy. We all agree.
Regular time, if they worked regular time, and say they're held over from the regular shift 30 minutes, if they take a vacation during that week, that vacation time is not applied, or in this case, none of it is applied. No earned time is applied. And the conversation is that the employees would have an adverse effect. They're not getting paid. When in fact, when you look at the actual numbers, do you know how many overtime hours the road department has done this year? Do you know how many call-out overtimes they've done this year? And I think the numbers have to be consistent with the conversation or the discussion. And the policies that we put in place for the call-out, there's just briefly looking at this, there's more call-out hours than there are being worked beyond their shift. And what we wanted to look at it from an administrative standpoint is it cost effective? Our decision, our policies, is it cost effective for the taxpayer? The employees are getting paid, and we want to make sure that there's no adverse issues with the employees. But just to make a decision because of a conversation, I think we need to look at the numbers. And that hasn't been discussed. We took it upon ourselves to look at the numbers to find out what actually, and with the new software that we have, it's amazing what you can pull up. You can actually get extremely detailed in the subject matter to find out what actually is cost effective for not only the taxpayers, but what benefits the employees. And I don't think, I'm not hearing that in the conversation in trying to make a decision. That's what I'm trying to say. We looked at this, we pulled from October. We started using time clock. I mean, the amount of call-out time compared to straight time, and the employees that got paid straight time, in some cases, the number, I guess I would say, do you know how many employees were affected where they took a vacation or were called in sick where they didn't get paid time and a half? We don't. I mean, we're making a decision, but we're not looking at what actually is happening, and there is a dollar attached to it. Which, I mean, I think that's our responsibility, is to look at the details of these decisions, and that's all I'm going to say. I mean, obviously the vote is a vote, but I know my administration, we went through and we looked at the details of the number. We want to see if, in fact, it's beneficial to the taxpayers and there's no adverse situation to the employees. If there is an adverse situation, then we bring it to the fiscal court and we make a decision. And I think that call-out policy was a prime example of that. And it's working. But we've only been doing it for 1 year.
I think the call-out policy is excellent.
Me too.
My issue would be if the person took vacation not knowing what was gonna happen. And our road department does a great job of cleaning our roads, and that's major, to me, that's the major issue, that or a large storm of where trees are down in the road, but primarily our snow removal. If we leave a guy, it does start snowing, put his week in, he's took a couple of vacation days. How does that go on? Are you going to say, okay, we're going to go home, we got to start cleaning snow in the morning, this is Friday, you're going to start cleaning in the morning at whatever, 5 o'clock, and which is typical, we'll let it snow out a lot of times, then we'll go in and try to get it off. Those hours, when you put them in, would that be call out?
Yeah, if it's outside of
That's call out?
outside of the normal hours, so if it would be like your situation, like on a Saturday morning, that would be a call out.
And that's a minimum of 4.
Yeah, now they work 6.
But if
that's-
they work all day and half the night is still time and a half, all that's time and a half.
Yep. And I think,
That's what I'm trying to understand, as long as, you know, in that situation, when would they not, in other words, if they had to stay over
That would be
from
the-
Friday afternoon into
and
the
they-
evening?
yes, that would be the situation where they would get straight time. If they had taken
Okay.
Monday, Tuesday as vacation, and by Friday afternoon,
And if you told them that we're gonna push snow and they said, hey, I gotta get home, my little boy's sick, and then you call him in an hour, is that call in?
yeah,
That's what's gonna, I mean,
Yeah, so-
that's the situation you're gonna get in, am I not wrong about that? You
Well,
know, I mean,
here-
they're
like-
gonna wanna go on home, are we gonna force them to work if we need
Well,
them to
here's the thing though, Bob.
for straight time?
They've got a sign-up sheet. So the guys voluntarily sign up for call-out. They're not being, there's men out there that don't sign up for the call-out.
I think what he's talking about is if
And-
he's working past their 3:30,
Yes.
he keep working.
Yeah.
Right. It would be straight time,
But-
if they took that leave time.
That's what
That's
I'm
what I-
proposing
If
to
they,
change.
yes,
My
and that's,
disagreement.
if they
Mine
took the
too.
leave time. Now, when you look at,
Aren't they gonna, but I mean, I understand that there are dollars associated with that, but there's also people, or citizens that are gonna be hampered by the snow on the road. Are they gonna just go on home and not work for straight time because they've taken a vacation day when we need them to be cleaning the roads?
And we
when,
expect
when
them
it
to be
was,
there.
when it was originally written, Wendy came over and we sat down, and that's the concern she had, was that the call-out, having somebody go out, there was nothing in place, and we identified that. That's why we put that call-out in place, so that they would get they'd get a minimum of 4. And when you look at the actual, this year that has been worked, you got an employee where, as far as overtime, 27 and a half hours overtime, 3.5 of those were worked. As far as, say, he got held over on his shift, he's out doing a project, but only 3.5 hours of those, and he got paid 3.5 hours overtime. And when you go through, that's what I'm trying to say, when you go through and try to find where somebody took vacation and they didn't get time and a half, as far as the adverse effect, if you will, from that policy, what we did put in place is actually working. Out of that 27 and a half hours, the majority of it was call-out hours. And it comes down to the management and the practice for the projects. I mean, there's some projects where they may go in and they may obviously have something where they gotta go respond to, and it's gotta be fixed because of public safety. If it's a road or something that needs to be fixed, they gotta fix it. And if it goes on beyond their shift, they're still gonna be out there, they're still gonna be doing the work. But as far as the policy is written, if they took whatever their time was, sick or vacation that they took during that 40-hour work week, because we're set up on a 40-hour work week, their time and a half would not be met until they met 40 hours.
One thing we are currently doing too is if somebody did take that leave time, like today, the way we would do it, and they did work over 2 hours, we'd add that back to their leave time. So instead of taking 8 hours on a Monday, and you got to 42 hours by the end of the week, we'd add that 2 hours back to that Monday, so they get to keep their leave time. That make sense? So it equals 40.
Yeah.
So you're just backing out
That's
their
what-
leave time.
Budgetarily, we've
They get their
budgeted
vacation
for,
back.
yeah,
Yes.
we've budgeted for 40 hours a week with a rounded number of overtime hours on top of that based on some historical data. So when we get into, I took a vacation day and want 8 hours for that, but then the next day I worked 10. That's gonna put me 2 hours over budget. That times all of our employees will have some impact. I'm not sure it's gonna be great, but
You brought up that situation. I mean, you've got a great all
Right.
out there and your great all operators. He took a vacation day and it's time to go home and you need this road covered up and finished. And he's done. He don't want to work for straight time, so he goes home.
Well, I mean, if he's got his 40 hours, he's getting time and a
Now, if he's
half.
he took a vacation day
Now,
on Monday
If he took a vacation,
and
then,
he's
So
still.
then if you worked 4 hours over, we'd add that, the
I
way we do,
understand
we
you'd
add
add
that
it
back.
back.
so.
I don't know. That's what I'm trying to, I'm trying to figure out what the guys that actually gonna do the work, for one, is that gonna be fair to them? Which, I mean, I'd probably just, adding the vacation back for me, I'd probably be okay with that. But, or the guys, I just don't want them leaving when there's a job needs to be done. I probably don't think that they would, but if they're working for straight time, I'm not sure they'd be getting compensated properly.
Working beside of somebody drawing time and a half.
That's the only thing. I
Well,
don't know.
and that's why I say,
If it's
looking,
not many hours, if it's not many hours, this is
There's-
happening
there's
in,
not. There's more
then
call-out
that's not a lot of
hours.
That's not a lot of cost.
there's more call-out than there is being held over. And when you look at the departments,
That's
the
what
road
I would
department's
expect.
probably one
That's
of
what
the-
I would expect always,
Yeah.
yeah. Even with tech and them, a lot of times, I mean, they're getting
They're
called
hardly,
up.
yeah.
They're getting called out in the middle of the night for specific jobs. I understand that. I just don't want to lose, I mean, I don't, I mean, if
The
guy-
employee's not, when we look at the time and a half, if they took vacation or sick time, it's not like, that time that's going back in to their earned time.
Right.
They're not losing.
Snow on the road, or if their road's cut and with a sewer going in, it would bother me if I thought that, the work would be delayed because of this.
I think part of that too is a management. I mean, if we're telling you as an employee, the department head's telling you, hey, you have to stay over, and you're like, no, I'm gonna go home. I think that becomes a disciplinary issue rather than
I don't know.
Can we
Well,
force them to stay?
sure. I mean, as an employer, you.
Well, they
could
have
you-
things
Could you
in-
let the department head determine whether they either were compensated at time and a half or they got their vacation back? The guys, a lot of them would want their vacation time back, I think.
Well, yeah, the way she's got it set up is they identify who wants to work or get called out. So they've got their people that will
But
work.
just this one situation where you continue to work, it looks like to me, and where you have a continuation on Friday afternoon.
Yeah.
Really that's the situation we're gonna.
They deserve time and a half.
Well, and
I
that-
mean, it's just not very often, and it's even less often that person may have already taken a vacation or sick.
Well,
I understand.
we're
Yeah.
discussing this. If there's
I'm a-
not many dollars involved, what's the deal? We're fair to our employees. I expect our employees, when 12 inches of snow are on the ground, to be there.
When
They're,
when
they're,
a dog-
and they're
And
gonna
they-
be
they
there.
usually answer
I mean,
the
they're,
phone, but
they're
we need to be
there.
fair
That's
to
not
them.
the issue.
What I
They're
do, what I
there.
do, I what if everything, I guess, to death, and it's always about, what if that road's cut, or what if that snow's on, and the guy goes home that you need, and you can't, you can't get that work finished for at least some additional time.
Yeah,
And
and from the,
that's causing a delay for the road to be put back in service and there's people down that road that need to get in and out. To me, that's the only time. It may be just a very seldom, if ever, that could ever happen, but,
Apparently, those are the statistics that
what
I
we,
just heard.
We need to be cautious, though, putting ourselves in a position to where we're paying out sick leave or vacation time. Because if we don't reduce that leave time, that's what we're doing.
And I'm just going to say it again, there is no adverse, the way it's set up now, and we've been at it for a year, the numbers that we see is that the policy that the department had put in place is working. The management level is down at their level. And the scenarios that we present, I just don't see it in here. And we have a responsibility to the taxpayers to also make sure that we put in place the best management practice for the taxpayers so that we're not just, we're not paying attention to the details of the dollars. A total for the entire road department since, I think this goes back to October, was 253 hours. And majority of that was call-out hours. I mean, those are, this is for this fiscal year from October up until, I think, May. The last date on this is May.
I think I ran it through June, but I think that probably was the last time that anybody worked.
Emily, you said, what did you say a while ago, that we wanted to avoid paying out?
Everyone's salary and payroll is based on the number of hours they're scheduled to work each week, which is 40. So if they're working, if they took a vacation Monday, Tuesday, and Wednesday, and they've got 32 hours of vacation time that week, Monday, Tuesday, Wednesday, and Thursday, and then Friday, they get a 10-hour day. We've not budgeted for that, for both situations. We've budgeted for either backing off vacation or straight time. I don't know that our overtime budget is large enough to absorb those
And
changes as is. It may be.
I think that
I
if
just
you
thought I heard
change,
you make a
you-
statement that was a significant number.
if you change the administrative code, you've got to look at the policy that was put in place for the call-out.
If you look at this year, it wouldn't be many because we
Correct,
not have
and
much
That's
overtime.
my point exactly.
And I don't think that's, it's got to equal out. If we put the call-out policy in place, and then we change the administrative code, you're going to have to pull that call-out policy because now they're working time and a half. And the numbers that we ran, there's not an adverse effect on the employee. I mean, from what I'm hearing, the scenarios, yeah, I mean, there can be a
There could be
scenario.
an adverse effect on the public.
It can, well, yeah, that's why the work,
And the employee.
the work,
Just
the
ask
work's
them.
being done. I mean, that's not, we fixed that with the way the administrative code was in place and the call-out policy. When the department head came
I
over,
understand that.
I mean, we put that in place. If we go back and change it, we're gonna have to look, because there are dollars attached to it.
There's always dollars attached. I don't know. I just don't want us to get in a situation where we can't get the work done in a timely manner, because a lot of times what we're doing is basically emergency service.
Yeah, and
Getting a road open or removing snow.
if you look at these numbers, the amount of call-out, which is emergencies, outside the normal working hours, I would say there's more on here. The work's getting done. I mean, if you look, we had one of the biggest compromises to our infrastructure, over $700,000, starting July 2nd of last year. We implemented the call-out in October, and since, I mean, they've done an excellent job of getting the infrastructure repaired where it needs to be, and they got paid for it. I mean, so the work was getting done, and the men were getting paid. Without that call-out policy, we all agreed that, you know, I'm not gonna come in and work straight time. And there's guys that don't even sign up for the call-out. I mean, so that's now a management issue for Wendy and Roy to identify their people that want to come in and work. But as far as the numbers, I don't see where it's not being, where the men aren't getting compensated. But I just throw that out there. If we do change it, then, you know, we've got the call-out policies that we put in place that we're gonna have to look
Policy is
at.
already in place.
Yes, and that was put in place because there was no.
And that's a good policy, and it's in place. I think all we're suggesting is to include, not where it says, but holidays does count towards overtime. I think what I'm hearing is that vacation, sick time, and holidays, comparing apples to apples there, can't differentiate between the three. They're all set up by policies governed that this body makes and puts in place, and it is earned time for the employee, and I just want to be fair to them because I expect them to come out and, when it's 12 inches of snow in that scenario, to push snow.
Well, and I think you got to look further into that, Rick. Do you know the dollar effect that that's going to have on the taxpayer?
What I just heard is it's very minimal.
But do you know
From
the
the
dollar
treasurer.
effect? And I don't think that's a known that hasn't been discussed.
I mean, the
And
taxpayers, all they
we've
get for
looked
their
into
tax
the
dollars is
details of it.
service.
And-
And what, you know, as
I'm
Bob
just-
said, they're,
You gotta
know,
look at
They
those.
expect the snow to be, and so do I, and I expect those employees to be there, and when we call on them in those adverse conditions, and I think they need to be rewarded, and not working beside somebody in that scenario. It's just been
I think part of the.
spoken by the treasurer that
This
was
is
a
probably
very
just-
little figure.
It's just an opinion probably, but I know you keep talking about working next to somebody that's not making or that is making overtime and you wouldn't be. Well, if I took 4 days of vacation and then Friday worked 10 hours, well, I'm working next to someone that worked all week and he's being incentivized by getting overtime.
Yeah, but you took your vacation that
I-
you'd earned.
no, I understand that. I
It's the same as a day worked.
Sure. And I'm just saying that, in
You
that,
earned that vacation, and when you take it off.
Right.
It's the same as a day worked. Doesn't matter where you are or what you're doing. No,
yeah, I just wanted to,
I understand, but it's, I don't know, it looks like to me, and I know there'll be people that would want those hours back onto their vacation. I would at least leave it up to the department head to allow that person to do one or the other. And if it costs some dollars, we'd have to amend in some dollars at some point,
And
later this year, later in the year to cover that. But from what you're saying, it's gonna be very little impact.
Well,
And,
we have to remember too, we had the infrastructure issues this past year, but we didn't have any snow.
I understand.
So,
Snows are the ones that it would get you, would get you in a situation, especially around the holidays. People take a lot of vacation, and that's when a lot of times we have our largest snow situations. I've
well, I think,
more than once seen my brother-in-law leave the Christmas dinner table and take off to go push snow. If he's been taking vacation that week, then I guess, I don't know, that'd be call-in, I guess, so he would get compensated. But there's situations where I'm concerned that our people will be there, and we need them to be there in those situations.
Need them to be compensated.
with the,
There.
and they're being compensated. When you look at these numbers, they're being compensated. If the administrative code is changed, then we have to look at the call-out policy that was put in place. Because then they're gonna be getting, I mean, you change the administrative code, then somebody, there's a dollar attached to it, a call-out's 4 hours, minimum of 4 hours. We did that so that mainly those three departments that would be affected by this. And just to add, when we sat down with all the department heads, only one department, actually two department heads, questioned the vacation and sick. The rest of the department heads, and one of them was even under the administrative code with a call-out policy, that wasn't one of the things that was discussed. So, I mean, it's the road department and text crew were the only two department heads that discussed the administrative code. And we knew that those departments would be affected. Those three, the rest of the departments, they don't typically get called out.
I understand that.
Yeah, that's not in question.
But the call-out that we put in place, there's more call-out hours, just looking at these numbers, than being held over. And I think we did put that in place because of the administrative code. And if we change the administrative code, then I think it's our responsibility to go back and look at that call-out policy. I think they do go hand in hand. So, just throw that out there. Is there a motion from either one of you for this amendment?
I would move that we, if there is no motion, if you're going to ask for that, I would move that we amend the red part where it says, but holiday does count towards overtime, that we include sick time and vacation time.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Section, looks like 5.33. County vehicles. A motion for county vehicles? Is that for-
From what we read in there is what Jeff,
Scroll down to it, I'll show you your options.
I think it's drug-free under B.
Getting there. I'm making a change real quick to the last motion.
Basically, county vehicles under 5.33 is changing drug-free to hyphen drug-free.
Yeah, I'd move that we accept that change.
Is there a second?
second,
All those in favor say aye. Any opposed? Motion carries. That was the drug-free section.
Oh, yeah. Here's the new language on that, if you guys are sufficient with it.
On which one?
On the. Yes.
Great.
Okay.
The next section is 5.51, expense reimbursements. Is there a motion for the expense reimbursements?
if there's no motion, I move that we add the language that was the judge just read.
Let's pull it up,
It's-
let me show.
The amendment is
What part are you at?
5.51.
I know, I'm trying.
He's starting to.
Change. Starting to sweat over here.
Okay. If you do nothing, that language stays in. Your motion can be to adopt as this is printed, or a motion to adopt it with the additional sentence at the end.
Either one.
So that's three options, or anything in the world you want to put in there.
I just assumed after our conversation that that was going to be part of the second reading.
Well, it was, I included that in the
Okay,
email.
okay, right. And that gives all 176 employees that option to travel with their own vehicle like they have in the past.
No, not 176. There are departments that do not fall under this administrative
Well,
code.
all our employees that do fall under that will have that option.
So is there a motion?
That we add that sentence,
Well, you're,
you read
There's-
that again,
there's-
I don't see it up there,
Your language.
but what?
Okay.
That I read, that you just read.
Acknowledge it's federal rate. You're using your own vehicle.
Right.
If that's your option.
trying to pull it up. That way.
email?
Yeah.
Well, it was on the board a while ago.
I'm getting there. That.
So after that would be the language that was proposed.
Yes.
Now, what you probably should keep in mind, I mean, whether
How is it, can you read it, because we need to make sure that we do this right. Can you read it as in full, as far as the amendment?
all right, well, yeah, I'll read the 3 with the additional language would be travel. The county offers a corporate rental program through Enterprise and county-owned vehicles for travel. These methods are preferred. Department heads and/or the appointing authority may offer to pay mileage at the federal rate, government rate, to use a personal vehicle if it's deemed more cost-effective. The department head and/or the appointing authority may also reimburse the county employee an amount equal to a vehicle rental if the employee still chooses to travel in his or her own. Alternatively, the employee may drive his or her own vehicle and receive mileage at the federal rate for miles traveled.
It's already in there.
Is that, is somebody making that motion?
Final sentence.
If that allows, what I think it allows and the intent, that the employee has the choice of the rental car program if they don't think their vehicle can make it from here to there, or,
Right.
or they can take, if they so choose, or more comfortable in their own vehicle, they can do it.
In order to make this read where, what I think makes sense, you would replace the last sentence with that sentence if you wanted to completely give it to the employee's discretion.
I think you also need to change where it says department heads and/or the appointing authority may offer, it should say will offer.
That's not what
Yeah, that's just what you were saying.
I said take that out.
Take that whole sentence out.
And if you know, I need to know if you make a motion, then I can tell you, I can read it in full.
Let's do it right here, then we'll read it for you.
So you should pay federal mileage plus the rate for a rental car.
No, and/or alternatively.
How can you take the authority away from the department heads and the appointing authority?
By this ordinance right here.
What is there a motion?
No, there is not a motion.
What is the
Jim
language?
suggested striking that, legally striking that, and clean it up.
There, is that your motion?
Yes.
Travel. The county offers a corporate rental program through Enterprise and county-owned vehicles are for travel. These methods are preferred. Department heads and/or the appointing firm may offer to pay mileage at the federal government rate to use the vehicle if it is deemed more cost-effective. Alternatively, the employee may drive his or her own vehicle and receive mileage at the federal rate for miles traveled.
That's it.
I know we've talked about this a lot, and I think the intent and for what people need to understand is this is the cheaper method. Cost effective. We've looked at it individually, on an individual basis, and it's, to go rent a vehicle, I can run a number, and it's $80 to $100 cheaper to do that. And I think that's what our intent was, to try to save taxpayer dollars.
Is that the motion? Is there a motion?
That is the motion.
Who made the motion?
I made the motion.
All right. Discussion. Do we know the numbers and the effect this fiscal year of what this policy, the intent in this policy was to save taxpayers money?
I understand that's my contention, that we've discussed this in great detail about 2 months ago for hours, and I don't think it makes 15 cents worth of difference in some of the scenarios that were given to from Calvert City back and forth. Like I say, I don't think it makes.
Here are the
15 cents worth
numbers
of
from
difference.
Enterprise, instead of just talking about it. Enterprise, when we put this in place, and again, this body voted on it and accepted it, we discussed this last year, and it actually did exactly what we wanted to do. Enterprise, using the federal rate mileage reimbursement, there was a total of 13,122 miles that was traveled by the county. Total days in trip, 88.95. When you add up the car rental daily price, which was 40.97, the Kentucky You Drive It tax, 6%, the VLF daily cost, $1.10, and cost of gallons per gallon, which they rated it at $2.50, mileage reimbursement rate at 0.535, and rental car gas mileage, miles per gallon, about 25. The total was about $5,272.98. If we took our own car and we paid at the federal rate, it was $7,020.27. That is a savings to the taxpayer. There's no way to cut around that. There's no labor-intensive process. When we did have a discussion after the first reading, you can actually, and Brad can demonstrate, I'll use me as a reference. I went to a conference last week. It cost me it cost the taxpayers $156.15. Rented a vehicle. If I would have drove my personal vehicle, it would have been about $225, because to Louisville and back is about 400 and something miles. I think it's 209 one way. That is a cost savings to the taxpayers. We put this in place for the taxpayers, plain and simple. The employees are going to get to the training that they need. The departments that fall under the administrative code, most of those departments have county vehicles. The one portion that is being left out is a county vehicle. A county vehicle saves the taxpayers a ton of money when you add it all up. The intent was to make it cost effective. When you look at who actually, as far as county employees, the reason why you see mainly staff and county officials is because most of our departments have vehicles. We've got a vehicle that we just approved for this office up here, this building here, for county employees to use. That's the intent, is to offer them a vehicle. And when you look at the top ones that benefited from it by using their personal vehicles, Commissioner Koch is at the top. Right behind him is Commissioner Boland, Commissioner Gold, our County Judge Executive Floater, GIS, Treasurer, the Treasurer's Office, the Finance Officer, Economic Development Administrative Assistant, and that's it. Those are the only ones that filed in this fiscal year from July 16 to May 17. We didn't include the last few conferences. There is a savings for the taxpayer, and the county is still providing transportation. Now, the administrative code as how it was written to where if you decline transportation that's provided to you and you take a personal vehicle, you don't get anything. We discussed that, and we put in place that you will get what is best cost-effective to the taxpayer. You'll get paid at the best cost-effective rate. So if you were to, say, have a meeting at the PAD office in Mayfield, you go to Mayfield and it's more cost-effective to pay at the federal rate, then we pay you at the federal rate, because that's going to be a savings to the taxpayer. But if you're going to Louisville, the most cost-effective rate or pay is a rental or preferably a county vehicle. And that has been demonstrated. I mean, these employees are doing exactly what was set out for them to do. And changing it, there's no need to have it in the administrative code if you change it. And the only ones that it's going to benefit are the really.
In my case, I'm actually still on call, but I don't turn in mileage anymore. I haven't in some time. I don't know where all that, when I got paid last, but I haven't turned in mileage. I drive my own vehicle because I may need to leave and go on an emergency call at any time. And I don't know if there's other employees that are in similar situations or whatever, but I don't turn it in. It's been such an issue. I just quit turning in any mileage. I don't have any problem with that at all.
Here's what this means, and I understand that, Bob, but here's what this means. The administrative code, as it's written, is going to save the taxpayers money. If you change it to what you're making a motion for, it's going to cost the taxpayers. I mean, that's it.
I think some of the things that you're not including in that when you're running the numbers was the scenario that, like I say, this has been discussed over and over and over again 2 months ago for several hours, and the scenario that's not included in that those statistics is the employee that lives in Calvert City, Kentucky, that goes to.
Let me just save some time, not to interrupt you, but we did your scenario, and we're going to show you that it is cost effective.
Okay, I got the floor now.
Brad's going to show you how to. There is a process out there to where you apply. We're going to use your scenario. It's cost effective. At the end of the day, it's cost effective to the taxpayer. The employee is still going to get to where they need to be. Where the one who benefits from this is the taxpayer, and that's what we should be looking at.
All right, so where are we going?
We just have a difference of opinion.
Where are we traveling
obviously,
to?
right?
Where are we going?
We're all trying to accomplish the same
Calvert City
thing.
to
Calvert City to-
Southside
to-
Enterprise.
Okay, all right, so going from Calvert City.
More importantly, what's your address, Rick?
This is ridiculous, and
It is.
I don't care to see your scenario.
Use my address.
You've interrupted me in my conversation
2351
to make
Lakeview
your
Church
point
Road.
without letting me make my point, as we have for several hours and 2 months ago in the discussion, but if I drive from my house
You have
to
to look
Murray,
it up,
Kentucky,
Irving Cobb.
my wife takes me over there to rent a car, and then she drives back, and then when I get back from Frankfurt after a 4-hour meeting, an 8-hour round trip to Frankfurt, I've got to call my wife again, and she comes and meets me over at Murray, so that's 140 miles from Calvert City to Murray that my wife is transporting me back and forth, and when I get in that rental car, it just happens that every place we go is north of where I live, and or any employee that lives in the north end of the county. That trip to Murray in that rental car, there's fuel coming back, twice and taking it back over there. So I just don't think it makes a 15 cents worth of difference in the scenarios. And in some instances, going to Madisonville, Kentucky, for any employee that lives in the north end of the county to go to Murray to rent a car, it's twice as expensive. They can be in Madisonville, Kentucky, by the time they can go to Murray and back, if they got to rent a car, go over there and rent it and take it back and have their spouse to take them over there.
Explain that to them.
Sure. So if you took your personal vehicle and you went to Frankfurt, it'd be $304.95 for mileage. If you went to, in your instance, you come from Calvert City, we're gonna go to Paducah and drop off our vehicle at Paducah and pick up a vehicle. That's 36 miles that we travel in our own vehicle at a rate of $35 per day. For 3 days, it's $124. So there's your scenario.
At the end of the day, we've got to look at how it affects the taxpayers. We've got to look at the numbers. The cost savings is in the numbers. With that-
That doesn't apply to, where are the numbers for the 140 miles to Murray and back?
It's not, we're going to Paducah. If you're taking from Calvert,
Okay,
you're picking up from Calvert, I'm taking my car and dropping it off at Enterprise, leaving it there, driving to Frankfurt
Okay.
for 3 days,
if you don't
come back
drop
to.
off a car in the scenario, I can say,
I'm not gonna.
we have a
when
motion
my-
on the floor. And
If I get dropped
still on the
off,
floor.
if I get
Let's-
dropped
let's-
off, you're not gonna get paid mileage for your wife to come back. You're gonna get it there and back. That's it.
I've got a motion on the floor.
Is there a second?
I've already made the second.
There's a second. We'll take it to a vote. Rick,
Yes?
Johnny, Bob?
Yes.
I'm going to vote no. I believe that's all the amendments. We'll move on with the next ordinance. Budget amendment, second reading, ordinance 2017-06.
Ordinance 21706, an ordinance relating to the annual budget and amendment thereof, whereas the County of Marshall has received additional funds now be ordained by the fiscal court of Marshall County that Section 1, the annual budget for the fiscal court 2016-17, is amended to include increased revenue accounts to the road fund of $123,000 and 911 fund of $34,440. Increased expenditure accounts, road department is $123,000, 911 is $34,440. Total increased expenditures of $157,440. Section 2, the amounts added into the revenue and expenditure accounts in Section 1 are for governmental purposes. This was approved in the first reading the second day of June, also approved by the State Local Finance Officer the 6th day of June.
We need a motion.
Approve the ordinance.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. We've got bids for bridge decking on Coldwater Lane. You want to open those?
Yep. I've got a advertisement that was in the Marshall County Tribune on Tuesday, June 13th, 2017. It reads this: Marshall County Road Department will be accepting sealed bids on a, man, that's really small, 588 something steel graded deck. The deck will be a 30-foot long by 24-foot wide. All bids must be submitted to the Judge Executive's office by 4 p.m. on June 19th, 2017. Bids will be opened in the fiscal court meeting on June 20th, 2017 at 9:30 a.m. For the information, please call Wendy Greer at 270-527-3173. The Marshall County Fiscal Court reserves the right to reject any and all bids. And there's one bid that was received on June 13th at 1:36. This is from E&H Bridge and Grading for metal grid deck, length 30 foot, width 24 foot, A588 steel, delivered $19,990.
You want to hand that to Roy? Roy, you want to take a look at that and make sure it's what you guys need? While he's looking at that, we'll move on to the annual bids.
All right. A advertisement was put in the Marshall County Tribune Tuesday, May 23rd for annual bids. Marshall County Fiscal Court will be accepting sealed bids on items listed below under until 4 p.m. on June 5th. Bids specifics and forms can be obtained from the Judge Executive's office. All bids must be submitted to the Marshall County Judge's office in sealed envelope, Marshall County Courthouse, 1101 Main Street, Benton, Kentucky. Bid awards will be announced at the Marshall County Fiscal Court meeting on June 6, 2017, which we're past that, but that's okay. The Marshall County Fiscal Court reserves the right to reject any and all bids, and there's a list of all the items that people bid on. So, this is for sealed rock bid. This is received on June 5th at 3:41. Rock bid, dense grade, $7.64. $7.64. Number 3, white rock, $9.98. That's bid price, these are per ton. 8 washed rock, $16 per ton. 57's rock, $9.93 per ton. 6-inch riprap, $9.58 per ton. 8-inch riprap, $9.58 per ton. 125 riprap, $9.58 per ton. 300 riprap, $9.58 per ton. 8-inch minus $8.42 per ton. 2.5-inch road base black, $8.42 per ton. That's from Vulcan Material. Is that the only other rock? Yeah. Okay. Second rock bid is received on June 2nd at 3:02 from Wynn Materials.
Who's that from?
This one or the other one? This one's from Wynn, W-I-N-N Materials in Grand Rivers. Dense grade, $8.50 per ton. White rock, $11.50 per ton. They've scratched out 8 washed rock to 9 M's, $12.25 per ton. 57's rock, $11.75 per ton. 6-inch riprap, $10.50 per ton. 8-inch riprap, $10.50 per ton. 125 riprap, $10.50. 300 riprap, $10.50. 8-inch, $8.50. 2.5-inch road base black, $9.50 per ton. Oh, are they gonna vote on it? Yeah, that was the only 2 rocks. Yeah.
However we want to do it, we want to go down each item or read all of them, however we want to do it.
Good, I mean, whenever he gets ready to make a recommendation, we could go back.
Yeah. And I think he said that to go back to the, first one, it meets the Coldwater, the decking meets the Coldwater Bridge. So if we want to take action on that.
The decking meets the spec. Motion to approve the Coldwater Lane decking job.
Second.
All those in favor say aye. Any opposed? Motion carries. Which one is that?
This is for fire protection. We just had one bid. It was received on June 5th at 3:12. It's from Murray Fire Extinguisher, Murray Fire Systems. This is for fire extinguisher annual inspection and tagging, $3 each. Recharge dry material or dry chemical, 2.5 pound, $10 each, 5 pound, 13 each, 10 pound, 18 each, 20 pound, 22 each. Hydrostatic testing dry chemical, $10 each. 6-year maintenance, $5 each plus recharge costs. Sprinkler system will be determined by system and quantity of sprinkler heads. And that's the only fire protection. Oh, he is here. Okay. If you have any questions, I think we have a representative from Murray Fire.
We have one bid on that, so. Is there a motion?
Motion to accept the bid.
Second. All those in favor say aye. Any opposed? Motion carries.
Next is for fuel. We got 2 bids, one from Max Arnold from delivered May 23rd at 2:54 p.m. All right, so let's see here. 87 octane gasoline, $1.79 per gallon, including state and markup. Markup price per gallon is 0.08 cents per gallon. LS diesels on road, 1.814. Price per gallon, 0.08 is price markup. HS diesel, 1.5895 per gallon. Markup is 0.08. They did not bid on the winter summer additive. Well, they did, I'm sorry. It is 0.015 cents per gallon markup. And that was from Max Arnold. Next one is from Midwest Terminal. Received June 1st at 10:16 a.m. All right. 87 octane gasoline, 1.957 per gallon. Markup price 0.115 per gallon. LS diesel, 1.9185 per gallon. Markup is 0.115. HS diesel, 1.9235 per gallon. Markup is 0.115. And summer and winter additive, 2 cents per gallon. Yes.
Arnold has a bid now, is that?
Correct.
We get, and they're their lowest bid. Move that we accept their bid.
Second.
All those in favor say aye. Any opposed? Motion carries.
Next one's for oil. First one, Max Arnold and Sons, May 23rd, 2:54 p.m. $15 W40 Fleet Premium, or Supreme, $1,412.50 per tote. That equals to 5.65 gallons. Hydraulic tractor oil, $1,097.50 per tote. That's $4.39 per gallon. Lithium-based grease, $350.39 for 120 by 1. GL4 gear oil, SAE GL5, 85W140 MP, $39 for 35 over 1. 5W30 synthetic blend, $247.50 per 55-gallon drum. Transmission oil, 50 synthetic, $172 for 35 1. DEF additive, $420 per tote. Antifreeze bulk, 50/50, 186 per gallon, 55-gallon drum. Concentrate is $350 per 55-gallon drum. That's Max Arnold. Next one is from Midwest Terminal, thank you. Received June 1st, 10/16. $15W40 Fleet Supreme, $1,771.88 per tote. Hydraulic tractor oil, $1,315 per tote. Lithium-based grease, $304.69 for 120/1. GL 4-gear oil SAE GL5 85W140 MP, $52.78, 35/1. 5W30 synthetic blend, $311.30 for a 55-gallon drum. Transmission oil 50 synthetic, $184.38. DEF additive, it's a 330-gallon tote for $474.38. Antifreeze bulk, $322.30, 55-gallon drum.
Is there a motion?
Make that motion.
For what? To which one?
The,
Max Arnold, it looked like had, is it Max Arnold? Is there a second?
Second.
All those in favor say aye. Any opposed? Motion carries.
Asphalt, from Jim Smith Contracting. Looks like this is the only bid.
Yep.
Received June 5th, 3:34 PM. Asphalt bid. Class 1 surface asphalt, $69.50 per ton. Class 1 base, $68 per ton.
Isn't that about the same as last year, Roy? Right on the dot, isn't it? Accept Jim Smith's bid.
only bid, yes. Second.
All those in favor say aye. Any opposed? Motion carries.
This is one for striping, received on June 1st at 11:19 a.m. I like that one. Oh. It's received from Brim Striping Company, 12 cents per linear foot. Is that pretty?
That's what it's been,
Is it
that's
what-
what it's been running, yeah, 12 cents for several years. That it, that the only bid?
I believe so.
Yeah, that's the only one, yes.
Motion to approve the strapping bid.
All those in favor say aye. Any opposed? Motion carries.
There's only one bid for salt. However, the FedEx delivery went to the clerk's office instead of the judge's office, and it was inadvertently opened. However, there is it was delivered on June 2nd, 2017, prior to the deadline, and the envelope inside is still sealed and hasn't been affected in any way, so I would suggest it be considered.
This is the salt bid from Compass Minerals. $60.28 per ton. We also included delivery pricing for that too. Delivery price per ton to Marshall County Road Department, $63.90. And delivery price per ton to Calvert City, which we did get an agreement with Calvert City for them to join us in this bid, was also $63.90. And that's the only salt bid.
What was the first number?
$60.28 per ton.
$63.90,
Yeah, that's-
$63.90 to have it delivered.
$8.
$63.90 to have it
cheaper than
delivered.
Last year.
Per ton.
Yeah, that's about $8, that's about $68 a ton, and the cities were getting charged $115 a ton.
That's not in addition to the $60
Right.
and 28 cents. This is total.
I would assume that it's an additional $3 and,
62 cents.
yes,
Okay.
to deliver it per ton. That's what I'm,
It, just so we understand, Wendy and I had talked, it's roughly $108 for a dump truck, county dump truck with an operator per hour, so for $3.92 or 92 cents. You can do the math, that saves the taxpayer quite a bit of money.
let me make sure. It doesn't list a minimum amount.
As far as what we have to.
Specs don't set out a minute, so it's just,
Well, the agreement that they've had in the past, if we order 1,000 tons, we've got to, whether we use it or not, we're obligated for 80% of that. Isn't that right, Roy? We have to pay for, so they give us a little leeway depending on the winter, but
it's not set out in the bid, though.
This has got the surfactant on it that we require. Don't we have a surfactant that we put on that to keep it from clumping?
We'll probably have to, let's confirm that before we take action on that.
That should have been in the spec, I think, but
that's about $8 cheaper than it was last year, so.
Yeah, we may need to just confirm that a minimum, I guess, before approval.
yeah, and I'd want to be sure. I mean, I'm sure it does have that coating on it, the surfactant on it, but I guess.
There's a bunch of specs in here on the actual salt, so
Okay, as long as it's got that on it,
I'll give
that's
it
what we
to
need to
Roy
be
to
sure
Yeah,
of.
let Roy take a look at it.
It gets pretty. Oh, yeah, well, I mean, we got some give to us, and it turned into one piece, just about. They had to dig it out. It's fine, but it can be used, but it's a lot better if it's got the surfactant on it.
no,
First one.
no.
Let's, before we forget, let's go back to the very first one on the stone. Vulcan and Wynn were the two bids.
I recommend the Vulcan material.
Vulcan.
Motion to approve the Vulcan material bid.
All those in favor say aye. Aye. Any opposed? Motion carried. All right, now we're doing culverts.
Next is culverts. We only received one from Hagan and Stone Wholesale, June 2nd, 2:50 p.m. It's received. $12-inch 16-gauge culvert with polymer coating, $9.66 per foot. 15-inch 16-gauge culvert with polymer coating, $11.60 per foot. 18-inch 16-gauge culvert with polymer coating, $14.50 per foot. 24-inch 14-gauge culvert with polymer, $23.20 per foot. 36-inch 12-gauge culvert with polymer coating, $47.50 per foot. 48-inch 12-gauge culvert with polymer coating, $62.75 per foot. 60-inch 10-gauge culvert with polymer coating, $99.50 per foot. 72-inch 10-gauge culvert with polymer coating, $118.75 per foot. It's from Hagan and Stone Wholesale.
We just spec with polymer?
Yep. When I talked to Wendy about them, she said just spec with polymer.
Okay, yeah, I knew we did them both ways before. but
Right.
They do hold up a lot longer.
Is that ballpark, Roy?
That's good.
Good. They do last longer.
Only bid,
Yes, sir.
motion to accept.
Is there a second?
Second.
All those in favor say aye. Any opposed? Motion carries.
Last one is for pest control. It's from Scott Pest Control, June 2nd, 3 p.m. This is a bid price for annual general pest control services, $5,640. And this bid price for annual termite control services, $2,965. This is for, attached you will find the bids for the annual termite maintenance renewals for all of the county-owned buildings that are covered by a termite contract warranty. The total cost for 1 year for all the 21 buildings that are listed is $2,965. The total pest control service cost for 1 year for all the 14 locations listed is $5,640. Total annual cost for the termite and pest control combined is $8,605. There are no charges in cost from the current there are no changes in cost from the current cost.
That answered my question, exactly the same as last year.
Yep, and then he also has each location listed by monthly cost and yearly cost, so
Same as last year.
Only bid,
on the bid.
move that we accept the bid. Scott Pest Control.
All those in favor say aye. Any opposed? Motion carries. You said that was the last one?
That was it.
Okay. We're going to old business. We got the bids for the engineer, landscape, and architecture planning services at Mike Miller Park. Since these are so big, I would suggest we open them and then let Dennis take a look at them and maybe come back at another court meeting to discuss.
There are 3 packages here, one from Bacon Farmer Workman in Paducah. I'm not sure I'm capable of opening this one.
My dentist is opening that. What happened to the tires, no tire bids?
Right.
We had no tire bids.
We didn't ask for tire bids. We talked and we thought we would just do them by the case, or, you know, what, you go to the cheapest dealer to get them, or however feel fit.
That's next.
Yeah, it's next.
Yep.
We have Baker Farmer Workman. And we also have one from Bell Engineering in Lexington. Again, statement of qualifications. And then finally, we have one from HDR. They're also located in Paducah, I believe. And again, so there's a lot of reading to do here, so,
Yeah, I'd say just bring it back next court meeting.
okay, that'd be fine.
We'll-
Hey, dentist, I noticed there's several books. Can I have one
There
of
are.
each?
There are actually 4 of each. So I'll take one and I'll just leave the rest. For you all.
So those are duplicate copies?
Yes, sir, yes. In fact, well, actually, here's one that has 5. HDR. I said that. And Bell Engineering also has 5. That may be what
Bacon Farmer should have 5.
each one of them has 5.
That's one for each member of the Parks Board.
Yeah.
We have a park board meeting next fiscal court. Do we have a park board meeting?
We
Schedule one.
can. When is the next fiscal?
Schedule or not?
We can schedule one,
Okay, that's fine.
and we got 30 days.
Just trying to get all these sorted out.
Can we get one of those, Dennis? There's
That's
5
what
and
I'm
one for
doing.
each
That's-
Park Board member.
That's what I'm doing here.
Okay, okay, good.
We'll move on with the old business, the bid for metal building at Road Department.
Oh, yeah.
This is an advertisement in the Tribune, Tuesday, May 23rd, 2017. Pre-engineered metal building bid notice. The Marshall County Road Department will be accepting sealed bids on new pre-engineered metal building. The building will be a 60-foot by 60-foot by 18-foot eve height with a 16-inch concrete floor. Specs can be picked up at the Road Department at 160 Homer Lucas Lane, Benton, Kentucky. All bids will be opened in the fiscal court meeting on June 6, 2017, 9:30 a.m. For more information, please call Wendy Greer or Rory Watkins at 270-527-3173. The Marshall County Fiscal Court reserves the right to reject any and all bids. And there are 3 bids. First one from Travis Construction in Calvert City, received June 1st, 2017 at 11:35 a.m.
Thank you.
We propose to install the building for a lump sum price of $201,542. Next one, Darnell Steel, received June 1st, 1:25 p.m. We are pleased to provide the following proposal to furnish all labor, material, and equipment for a new pre-engineered metal building as per the specs furnished by the Road Department and enclosed scope of work. See add alternative to meet Kentucky Building Code. Price, labor, $56,957. Material, $97,879. Equipment, $8,245, for a total cost of $163,081. They also list alternate labor at $2,000, I guess alternate material at $2,811, and equipment at $440 for an additional cost of $5,251. I'm assuming that's a contingency. Is that anybody here from
Yep.
Darnell? The additional, is that just a contingency?
Kentucky Building Code,
Okay,
the scope of work didn't meet the Kentucky Building Code.
so the additional $5,251 is to meet the code?
Yeah.
Okay, so is that on top of the 163,000?
Yes.
Okay. So total looks like it's around 168,332.
Are you saying that our specs didn't meet the building code?
That's what my metal building manufacturer said. It was due to the installation in the ceiling and the walls.
Thank you.
Last one. Last one is from Glenn Harris Construction out of Benton. propose hereby to furnish material and labor complete in accordance with the above specifications for the cost of $163,220. And there's a list of scope and some additional information.
What was that number again?
63,220.
163,220. I'd assume we'd let Roy look over those and make sure they all meet spec.
While he's looking at that, we'll move on to new business.
Can we take a break before we
Need a break?
start new business?
We can.
Since we've got a lot of new business.
We can. Why don't we just go ahead and,
That's okay.
Motion to recess for
yeah, my staff knows I push through, but that's fine. We can do it.
Come back when?
In 10 minutes? Talking with Dennis during the recess.
Oh, that's right.
July 18th is our second fiscal court meeting. We can set a Parks Board meeting, and that'll give him time to go look at some of the projects that have been completed by the three entities that put in a bid. So if we want to set that now, we can go ahead and do that. July 18th, has anybody got any objections to that? Do it after fiscal court. The Park Board. All right, we'll move on with new business, the need line deed. The lease agreement that we identified, there was a lease with the county and Needline. Needline had paid off that note in 2015, and in that agreement, once they did that, then they would be first in line to take ownership of that building structure. So we asked the county attorney to present a deed for them, or for my signature, so that they can take ownership of that building. Do you want to read that, Jeff, or summarize it, or?
Yes, sir. This is a deed transferring a piece of property on Main Street, North Main Street in Benton, from the fiscal court to the need line pursuant to the original agreement and lease which was satisfied in 2015. And based on this deed, the county will not have any interest in that property.
motion to allow the judge to sign the deed over.
Second. All those in favor say aye. Aye. Any opposed? Motion carries. Next is the ordinance 2017-07, Alcohol Beverage Control Amendment. It'll be the first reading.
This is ordinance 2017-07, an ordinance amending ordinance number 2015-05 entitled, "An Ordinance Regulating the Sale and Consumption of Alcoholic Beverages in Marshall County, Kentucky." Whereas the Kentucky General Assembly has made extensive changes to statutes regulating the sales of alcoholic beverages in wet territories. Whereas Marshall County Fiscal Court feels it necessary to add a specific regulation concerning issuance of quota retail drink licenses. Now therefore be it ordained by the Fiscal Court of Marshall County that ordinance number 2015-05 is hereby amended to read as follows. Under section 10.039, conditions, prohibitions, and restrictions, subparagraph T, pursuant to KRS 243.230 sub 2, quota retail drink licenses shall not be issued in any areas or localities subject to the authority of the Marshall County Fiscal Court. This decision is made in part due to the lack of comprehensive zoning which would be needed to adequately control the location of such establishments. 10.045, signs and advertising. The heading unless expressly permitted by state statute or regulation, the sub A is completely removed, sub B completely removed, sub C is renamed sub A. It shall be unlawful for any person holding any license under this chapter to give away or offer to give away anything tangible of value as a premium or prize or for any other purpose in connection with the sale of alcoholic beverages. Original D is now B. Any advertising by any licensee under this chapter shall be in compliance with this chapter, KRS 244.130, and any regulation promulgated pursuant to KRS 244.130. Original E is now C. No licensee shall publish or display advertising that is false or misleading, nor shall any licensee publish or display advertising that implies that consumption of alcoholic beverages is fashionable or the acceptable course of behavior, or advertising that contains any statement, picture, or illustration implying that consumption of alcoholic beverages enhances athletic prowess, whether or not any known athlete is depicted or referred to, nor shall any license publish or display advertising that encourages intoxication by referring to the intoxicating effects of alcohol, or the use of terms such as high test, high proof, or extra strong, or depicting activities that tend to encourage excessive consumption. First reading, June 20th, 2017.
If this change is a result of House Bill 183, and there was numerous changes in there. I know this is the most urgent, or seems to be the most urgent of the changes. Is there use, and I haven't read the other 138 changes that are associated with that House bill, but do you foresee any other changes coming forth because of that?
Well, you know, every year's a new year with the legislature.
Well, I mean, with those changes, in those 139 changes associated with House Bill 183, that was just one of the changes.
That's the only one that would require us to take immediate action as set forth in under 10.039T for his quota retail drink licenses.
Right.
Because basically the state law allows those to be anywhere, and I think the thought that is expressed to us is that when this was being addressed in Marshall County, the one issue that both sides campaigned on was that no bars. And this will eliminate, or our attempt at this point to eliminate that and keep it as the as the law was when the vote occurred here in Marshall County.
Of course, I'm not sure about all the different levels, but there's one portion of this says that they're eliminating the 50 patron limit.
That's what creates the need for this.
That's what I mean. This is gonna, I mean, it doesn't say that we're gonna maintain the 50 patron.
eliminating the 50 patron limit would allow retail drink licenses.
Right.
Which is, so what we're doing,
Okay.
what this is doing is specifically addressing no retail drink licenses, because before the state law prohibited it.
Okay.
And now we specifically are attempting to prohibit it.
Okay. I just was trying to, but we're not gonna have retail, but are we gonna still have a 50 patron limit? Where's that gonna say that? State law doesn't say it.
No, the 50 patrons is for the NQ2 license, that's the restaurant license, and they are doing away with the 50-seat requirement.
No, we won't have a 50-seat requirement.
The quota retail drink license that they're referring to is, they don't have to have a restaurant at all, and they would be able to
Yeah, I
serve.
understand that, but that's what I thought. Now you're gonna allow very small restaurants, I guess, to be able to purchase a license.
That's right.
Is that correct?
If they're a restaurant, they can have a license.
They still have to meet the food and
Still have to
alcohol
meet the
sales
50-50
percentage.
Percentages, yes.
Yeah,
but
the
they will not have to have
50/50
a
food,
50 seat
the alcohol
requirement.
percentage is still there, but not the 50 seats.
Okay, I'm not sure. I don't know. Appears it to be, could get very close to a bar if you just have any level of seating.
True, I mean, it's loosening it on that, on the state level.
Why would we not just keep that in our ordinance?
We could. Well, you know,
This could be
this is kind
challenged, I assume.
like these provisions down lower under signs and advertising, when, you know, as we found out, once we started trying to regulate where these you could be in relation to churches and everything else, we found out that there was, the state would veto that, and if we enforce this and ignore our.
Okay.
So, in our research, we're reaching, in an effort to regulate that, and, you know, they could do the same thing with this provision. They could choose to ignore it.
When we were drafting our original ordinance back in the early stages, our first ordinance, it was perfectly clear to me that the distances and all that was just a suggestion, and if somebody took you to court of law, you were gonna lose every single time.
Right.
And the same thing with the signage, because if Pepsi-Cola can advertise and have a banner outside a grocery store, so can Bud Light, and you didn't have a leg to stand on. It was only a suggestion from this body, and I understood that fully when we did that.
But the 50 patron limit was something that everyone understood, I thought.
Yeah, but they still have to have 50% of their monies from food.
I'd actually rather see that 50 patron limit remain, but anyway, what does that say?
Comfortable enough to move that we adopt the.
That's the
Well,
first.
and I'll go back and pull our notes on that, and if we need to plug something else in between now and the second reading, we can.
All right. With that, the second reading, let's see, we've got, Emily and I had spoke, typically at the end of the fiscal year, we select a day at the end of the month. I asked her what day would work for her to get last-minute bills and things paid, and we looked at the 27th, but that's one of the things that we need to identify as our next court meeting to end out the fiscal year. Is the 27th, which is Tuesday, is that going to be good for everybody?
I'm not 100% sure, but about 75% sure I'm okay there. Got to go to a wedding, being forced to go to a wedding.
June, what's the date again?
June 27th.
But that's the only thing on the agenda.
That's going to be for any last-minute things for the agenda, too.
Is that at 8 o'clock?
We can do 9:30.
While we're doing this, what are we gonna do? We're gonna meet on 4th of July?
Well, yeah, that was another date that we got to discuss. So is June 27th at 09:30 good for everybody?
I'm good with that, man.
Me too.
Say I'm 75% sure I can be here, but I have no problem with you meeting without me, if that's the only thing on the agenda, Major. I'm against open bars.
All right. Now, July 4th, do we want to, that's on a Tuesday. Do we want to look to change that? Obviously, we do, but what day do we want to choose?
So if we have the 27th, do we need it, do we eliminate it, or do we think we need it?
We need it to pay the bills and stuff.
I mean, that'll be
Vendors don't
the
get
week
paid if
prior.
we don't have to.
Yeah. I mean, we can push the 27th and have the 18th in July.
That would be an option.
Okay? I'm fine with that. All right, and we'll just push the 18th.
No meeting on the 4th.
All right, that takes care of the meetings. Next on the new business, the local board of assessment appeals appointment. Y'all should have gotten from Tony, the appointment is the fiscal court's appointment. Do y'all have somebody you want to appoint?
I just asked Tony yesterday and asked him just a while ago, and he said he didn't have really a preference. He said Kip Mathers was an attorney that was getting off, and he said that worked well. And also, they don't have anybody in the construction industry on that board there. So either one of those would, but he did not have a personal preference, I asked. Who are the other two members of that board?
Should have been in the packet. You got Monty Collins, who we appointed last year.
Okay, that's real estate, right, and,
I
Kip has
believe,
stepped down.
believe
His term
it's-
is over with.
Brent Evans.
oh, Brent Evans from Mayor Jones appointed him, yeah, okay.
But it's the fiscal court's appointment. So whoever y'all want to appoint.
Well, why don't we make that decision then, since we haven't had time to contact people, put that the 27th, and we'll make that appointment with fiscal court, which is 4 people, but we'll make that decision.
So we'll move it on,
That's okay.
move it to the agenda on the 27th.
At their next meeting, that person will not be able to attend. Kip Mathis is in July meeting, so.
We'll move on with new business, the building inspector agreement with Randy Duke. Section 4, I think, is the addition to the contract.
The, getting to level 3 certification.
Yeah, I'll just read it. This is the addition from the board. Section 4, Duke shall successfully pass all exams required in order to achieve certification as a Level 3 building inspector and plans reviewer by July 1, 2018.
Did you say he has successfully completed? No, he has not.
He will by 2018, now he understands this.
Right.
I mean, he understands.
Casey has talked
Yeah.
to him, and he was fine with that.
Okay. Approve the change in this builder inspector agreement.
Second.
And accepting it.
Accept it, yes.
All those in favor say aye. Any opposed? Motion carries. Next on the new business is the performance contract and RFP approval for release. Brad, do you want to go over that real quick?
There is a about 10-slide presentation I want to just breeze over. But we've had some discussions about this, and I think moving forward, the purpose of today would be to get the approval, the court to advertise for proposals for performance contracting. But just to give you a little overview on what performance contracting is, it's a procurement method that allows the county to make infrastructure improvements that result in guaranteed utility savings covered by part or all the project costs. And it's outlined by KRS 45A 352. And I think you guys have this presentation in your packet. Okay. So here's the enabling legislation for model procurement. The GESC for public agencies exempt from debt limitations, definitions, financing projects, procedures. So you can, on your own, look up those KRSs and just verify that this is a legit process. So basically, performance contracting reduces your energy use, reduces water usage, reduce operating and maintenance cost, and reduce emissions and reduce waste. It's basically leveraging your guaranteed savings to pay for building improvements. I think previously we've been more of a reactive in nature by our infrastructure on our buildings, our HVAC units, water consumption, and I think we've seen some places where we could save some money on reducing our utility spend and our maintenance operations. I've had a lot of conversations with Gary Teckenbrock, our maintenance supervisor, and the amount of maintenance that they put into some of the equipment in our buildings is high, and I think this performance contracting can move us away from some of those maintenance and operations and having some savings there as well. So this is just the benefit of using a energy savings performance contract compared to basically self-performing. Your project approach is it's low initial cost at first for if you do a plan and spec, but performance contracting is low life cycle cost. You can financial source, you'd have to do a capital outlay if you do it yourself. In this performance contracting, you can use existing budget and do financing and put it into a budget as payment. You can kind of look through there, but basically what I see from this is very, the risk gets taken from the county and puts on the energy services company. I think that's an important piece. I know a lot of things we'd like to do in-house, but I think after studying and researching performance contracting and talking to other counties that have utilized performance contracting, that seems to be the biggest one is the risk. So your program goals, transfer the risk, as I said, upgrade infrastructure, reduce the utility expenses to help fund the replacement of assets, improve life safety and working environment, increase comfort and decrease energy usage by adding an automation system. So everything would be automated through computer and where you can adjust temperatures through a control. Better lighting levels to improve living and working environments. Again, proactive and reactive maintenance, improved services, accurate real-time information, and improved reliability. And then financial benefits, it gives the county the ability to fund upgrades without having to raise taxes or find new money. Self-funded through energy savings. So the more energy savings you get, the more money you're saving, the more you can spend on other things in the county. So here's our goals. Innovative project, self-funding solutions that reduce operating costs while increasing comfort and productivity, allowing jail to focus on operations. We highlight the jail there because we've talked to energy groups, and they've identified the jail as being probably, obviously, our most costly as far as energy use and water use and electric use, and that's going to be a big one that they're going to identify a lot of improvements to. Improve building comfort and safety levels, increase efficiencies and improve technology capabilities, reduce energy, water, and unpredictable operating costs, and reduce financial risk associated with capital improvement projects. Performance contracting uses savings within our existing budget to fund all improvements, and ESCO guarantees the financial results. I think that's a big one, as I talked about risk before. So here's our challenges. Limited funds, tightened budget, code compliance, reactive facilities department or outside contractor, rising energy operating costs, deteriorated infrastructure and facilities. We have some old infrastructure in our buildings, and I know it's not looked probably highly upon to spend taxpayer dollars on our own buildings, but I think when people see that the amount of money that we can save by being more energy efficient, I think that's a better steward of taxpayer dollars than just being reactive. There's no ability to control our buildings right now and unfunded capital improvement projects. Here's our results. Reduce energy operating costs, lighting upgrades and controls, control system improvements, water infrastructure upgrades, mechanical upgrades, indoor air quality and comfort issues, repair deteriorated equipment or buildings, weatherization, and education tools. Like I said, today, we need to take a step towards doing this. So today, we'd like to request the fiscal court approval to issue that RFP. And as you look, this is the kind of the timeline that we've outlined to do this process. On June 27th, we would advertise in the paper if you guys so choose to approve that. Then we do a mandatory walkthrough with the ESCOs on July 11th. That would be meeting here at the courthouse and taking those representatives from those ESCOs to each of our facilities so they can have a hands-on approach to their proposal. Then their responses would be due on August the 8th. Then you would select an ESCO to develop the savings, August 15th. Project development and agreement initiated on in August sometime in 2017. Project team develops final scope. We're going to put together a committee that will focus on this process. Then legal contract review, hearing, and financing in November, and then construction may begin in December. So, like I said, I was going to fly through that real quick, but do you guys have any questions about performance contracting and the process that we're outlining here?
I have a question. Where did we get this document?
We created it with an ESCO,
Okay.
with the guidance of an ESCO.
Okay, does that eliminate some of the possible bidders?
No.
Would that be there? The reason I say that, on page 4 of 12, qualifications, they recommend that proof of accreditation and good standing with the National Association of Energy Service Companies is required.
Yes.
Is that,
Required.
that's what?
It's required. The ESCO is required to have that accreditation.
Well, if we adopt this right here, it is. But that's, but are we eliminating companies that competition?
Why would you?
If in fact they're not a member of? I mean, are you all a member of this group? Okay, are you all a member of?
Part of the statute and part of the requirement.
Of the NACSCO accreditation group, we are a NACSCO member. But accreditation just means that you have handpicked your last or 10 of your best projects over the last 5 years and submitted them. The ones that are at risk or suspect, you have not provided to NACSCO for consideration. So they're looking at the best of your best and not the ones that might be towing the line a little bit.
Who are you with, sir?
Perfection Group, Matt Callahan. And NACSCO accreditation is not part of the KRS legislation, just for
Sure,
that
yeah.
fact as well.
What's the contract term gonna be with them for the length of
Say that
time?
again, Matt. What did you say at the last?
I said, NACSCO accreditation is not part of the KRS legislation either, so.
That was my question.
But it would be, you know, picking the best of the best, if, you know, leaving that in there.
Well, it depends on who you ask. If you ask these folks, that's not necessarily true. They just gave that explanation, or.
Yeah.
Well, I'd like to add, we have done multiple projects for many counties across the state. Nick Roberts with Perfection Group, by the way. And we're going through the process for NACSCO accreditation, but with that short timeline there, we wouldn't be able to respond to that. So that is literature in that RFP document that would limit competition, which we know better competition, better for the taxpayers, so.
Yeah, that's my only concern. I just don't want to have something in here that eliminates the process and the.
I'm curious. You said you're going through the process for accreditation?
You can do it 2 times a year, July and January. January is when we're gonna have our submittal data in. It could take 6 months or better to get that back and approved through the organization. They look at everything from your business practices, the markets you serve, how you go about your business, your integrity, et cetera, and the project values that you bring from not only just looking at 1 or 2 ECMs, but the breadth of ECMs that you provide to your customers. So it's a detailed process. It's not something that you can go in and get rubber stamped, but we'll be doing that in January.
Which, I mean, I totally understand the rubber stamp. I mean, that's a good thing. I'm curious, why are you wanting accreditation?
Well, because it adds value to it, and if we have a RFP that comes out with language in it like this, that is not under KRS legislation, we've been pushed aside because of that basis. And we would rather rely on our track history and our case history with the 80% of the counties that we've done
Sure.
with the success of those projects than having to pay for something that actually, at the end of the day, costs the customers money.
Right, and I'm just trying to learn this. The certification has been in place for how long? Do you know?
NASCO? Oh, I'm not sure. Maybe Teresa can answer that.
Does anybody know?
NASCO's been around for a long time.
I would say 25 to 30 years, not exactly sure.
How many members would they have?
I would have to look at their website because it does change when new folks come in. Excuse me.
I just,
Who is-
that,
There are different levels of accreditation, and there are those that are ESCOs that are fully accredited, and those are your top-ranked ESCOs. And it does not increase the price of your project, much to what Matt said. It's the best of the best. In our state, we probably have, I would say, 7 off the top of my head that are NAESCO accredited companies. And they're
State has 7?
Very high quality. And I'd say there are probably 8 or 10 who operate in the state, and some of those just are not accredited. So it's just a high quality statement that you can include. It is not prohibited by the law. It's actually encouraged by the state.
When did y'all get y'all's certification?
I would have to check, Judge. We've had it, I would guess, I would say 15 years or more.
Okay. And how long y'all been in business?
We'll celebrate 25 years next year.
25? How long y'all been in business?
65 years.
65? Have you ever had the accreditation?
No, we haven't. We haven't applied for it.
There's not been the need. The Department of Local Governments also has a sample RFP out there, and they don't require that either. It's a way to really limit competition.
When do you anticipate that you'll get accreditation?
Can't tell you. We're going to apply in January.
In January?
However long that takes. I don't know. Several months. It's not going to be the next week or next day thing.
I'm asking these questions because I'm trying to understand. I mean, I know in law enforcement, they got accreditation, and in other areas, they have accreditation, and I'm just trying to understand the process.
Well, if you take a look at that, like I said, you're submitting your best projects, not the ones, you're not submitting your entire portfolio. So the ones that are suspect or on the brink of being good or bad, the NAESCO group never sees those things. So it doesn't matter. You're going to give your top 10. You're not going to give your bottom 5 that you got. So that's what they're looking at. They're not looking at the entire portfolio. So that's something to consider when you're thinking about NAESCO accreditation.
Sure. And I just want to make sure that the conversation doesn't get enveloped in who's got accreditation, who doesn't. We want the best for our infrastructure so that there is a tax saving opportunity. I know that there's RFPs, that there's other counties that have been doing this. I know McCracken County's doing it right now. But I mean, that should be our focus, is to make sure we get the best company that's going to do the best job for us. Okay, all right, appreciate it, gentlemen. Did you have anything else on that, Brad?
No.
This is just an RFP to send out. I mean, there's no, we're not identifying any company to.
No, at this point, it's just the request to advertise for proposal.
I'd actually prefer that you remove the accreditation, but ask that they provide it if they have it.
I think there's provisions within the request that it doesn't necessarily allow, it doesn't necessarily knock them out. I'm not sure if it's, I mean, I guess we could remove it.
If you remove their accreditation, and then we just, they can cite that if they're accredited, and we can take that in consideration when we make a decision. If the state doesn't require it, that would be the best way to do it is to get the most bids.
Is there anything in here that says that they cannot?
It says they're required to be accredited, I thought it said.
Proof of accreditation in good standing is required.
Yes, it says they're required.
I think we can change the language to where we can open it up for anybody.
So, I mean,
You might
looks
look
like that'd
at
be
qualified
simple.
bidders, when they read that way.
Can we say is preferred?
That'd be fine. I mean, just so
Just
we
that
can,
language, just so,
so they can, just so they, I mean, we can consider that certainly as part of our, when we look at the bids.
Are you one of 24?
One of many.
There's probably, it says only 24 have been accredited.
Probably so. I said there were 15 probably, or 7 in the state. Yes.
That was my
Well,
concern.
my thing is, I don't think it's saying that they can't bid. I wanna make sure. that-
Right, I just,
So we can change that to where it's preferred.
But not required.
Required to show proof. But I just wanna make sure that the required doesn't mean that they can't bid, they can still bid. But we're gonna change it to where, it's preferred.
That'd be fine.
All right.
I think that'd be best.
do you have any more questions for any of the representatives here today? Do you all have anything you would like to add?
I think it'd be good. Program.
To approve the request.
With the
With the
change.
So the change,
of
preferred.
preferred. Is there a second?
Second.
All those in favor say aye. Any opposed? Motion carries.
Thank you.
Next, on the new business is the Morris County Exceptional Center, contract employee agreement. Do you got that, Jeff? I don't see that in.
no, I haven't.
I don't either.
I wanted to make sure that I knew what the terms as the court approved, and I can plug those in.
Why don't we, if it's not completed, why don't we move that to the 27th agenda?
Hey, can I ask then, I think what the proposal is that there's one employee that will be on the fiscal court payroll. And what I would suggest, through the 1st of October, I believe. And what I would suggest is that be documented, that, I mean, as it is.
I think it's the end,
Arrangement
first of
is-
November.
1st November, end of October. The pay, and if that's being and how, if apparently it's being reimbursed, and that relationship will continue. I would, based on the suggestions of the auditors, I would suggest that we have the court, in doing this, designate someone as a supervisor so that that person knows where that employee is, what he's doing, when he's there, that sort of thing. I won't change what he's doing,
You got,
because you're donating that to the exceptions through the end of October.
let me read your letter, that way the people that understand what's going on. This is from Jeff's office on this subject matter. Pursuant to your request of June 8th, 2017, I'm writing to clarify any legal issues relating to employees at Morris County Exceptional Center who are on the Morris County Fiscal Court payroll. It's my understanding that each of these employees are hired and supervised by Morris County Exceptional Center Board. The auditors have raised issues this year relating to county employees that are being controlled by some entity other than the county. Morris County Fiscal Court can contribute to outside organizations as long as the monies are used for a public purpose. No question has been raised as to the efforts of the Morris County Exceptional Center being a public purpose. based on my review, the auditor's finding in the current law, the relationship between the Marshall County Exceptional Center and the Marshall County Fiscal Court is not illegal. However, it needs to be modified. There needs to be some documented agreement of the relationship. This agreement needs to reflect the exact status of the employees. Finally, if the employees are going to be on the Marshall County Fiscal Court payroll, there must be documented approval by the Marshall County Fiscal Court and method of supervision. And that's from the county attorney's office. What had happened in this relationship is that the auditors reviewed it, and in fact, those employees are county employees based off the auditor's opinion. However, the auditors also state that all business as far as hiring and managing of employees have to go through the fiscal court. And that wasn't taking place. So we need to clear that up. But in the process, when the fiscal court voted to do the payroll extension for July, the Exceptional Center reached out to us and they asked if they would be subject to that. And since their employees are considered county employees, we said yes, because we can't differentiate between county employees. And so they have since, the board has voted to seek private options. And in the process of that, you've got county employees that are no longer going to be county employees, one in which has got 4 months till retirement. And so this agreement that the fiscal court would go into would to be a legal agreement through the fiscal court. He'd be supervised by the county, and then that way, with the date of, I think, end of October, November 1st, he would be able to, then he wouldn't be an employee. So that's the basis behind all this. I know we've discussed it, but we can sit down and come up with the details of the agreement and bring it back on the 27th. Has anybody got any questions on that?
Just need to make sure we all share that information, because the 27th, that's our last opportunity if there's any changes. So if we get a packet before, maybe Friday before or something, that we can make sure there's no changes, or we're all in agreement. But and I'm glad you explained that way. I think that we're just doing the right thing to treating an employee, a 20-year employee, the way we'd want to be treated if we were 4 months and there was going to be such a change. I think we're doing the right thing there.
I spoke to the individual, so he's aware of the process. So. Yes.
In regards to the agreement, there was another, we had discussed lease agreements with county properties and any nonprofits or any entity that's occupying those properties, that we have an agreement with those entities. And I think if you can get that drafted as well, Jeff, by the 27th, we can discuss those agreements as well. All right. So we'll move that to the 27th. Next, under new business, grant application for Friends of Chestnut Creek implementation. We just need the court's approval to move forward on that. Basically, it's a grant that's required signature, so the court would have to approve that. This is what we have named Maggie's money. Trying to keep, we've met so many different times, but it's.
Well, you need approval to, motion to approve your signature on this document, Judge?
Correct.
I move.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Next, road department new hire recommendations. You got those, Roy? The road department had their board meetings. I think y'all had 10, and 10 good applicants, and they went through the process, and they identified 3, or actually, I think you did 4, one in case one of them declines. Okay.
They was Daniel Jameson, Jonathan Poe, and Danny Brame.
Who's the third?
Danny Brame.
Okay.
And then they've identified, I spoke to Wendy, but they've identified a 4th person in case one of these 3 decline. They have a contingency plan for the
They'll be
pool,
replacing who, you know, off the top of your head?
whoever declines.
The new hires.
Oh,
The
the,
new hires will replace who?
Yeah, the retirees.
retirees.
Coy.
Well,
Boy?
yeah,
Coy, Steve Ruggles, and John Henderson.
and, yeah. Now, they're retiring at a different time. You got 2 retiring at the end of this month, and then 2 at the end of July. Yeah. This month.
How are we gonna hire those employees then? Just all at the same time?
These employees.
That's what?
These 3.
Those 3 we're replacing with these 3.
Say one more time.
Steve Ruggles and John Henderson are able to retire. They are retiring at the end of this, their last day is June 30th. These 2 of these 3 will replace those 2.
Right.
Then we're losing another one at the end of July. The 3rd one of these would replace that employee.
Okay, I understood that, but my question was, of those 3 employees mentioned, who's gonna be the first 2 hired, and who's gonna be the 3rd hired?
Oh, I think we're hiring them all at the same time.
Oh, okay, that was my question. And we're for a month, we'll just have an extra employee compared to what we usually do. Okay, I just didn't know the process. I know a couple of those guys, and Danny Brame he can take a quarter off the top of your truck without scratching it with a backhoe, so he's a good employee. Will be a good employee.
All right. When you just need a motion.
Motion to approve the new hires.
Second?
All those in favor say aye. Any opposed? Motion carries. We go into board appointments. North Marshall Water District Board appointments. I've got 2 board members whose terms expire. And I've made Dean McCoy and Tim Watkins is the recommendation to be the 2 new board members to the North Marshall Water District. Is there a,
Who's expired?
you got Shadowan and Driscoll?
I have a little problem with Mr. Shadowan. I know we're dealing with sanitation district, what we're dealing with in Draftonville, and him as a member of the North Marshall Water Board and past superintendent of Marshall County Schools, and I think he would be a very integral part of that process and looping in and obviously knowledgeable of at least two of the 3 of those entities, and I would certainly like to see him remain on that board myself personally.
The nominees or the board members that are being presented are Dean McCoy and Tim Watkins. Each one of them have, Tim Watkins has been, actually he's chaired the school board. He sat on that board for several years. I mean, each one of these gentlemen have experience as far as sitting on boards. There's been several requests from citizens in that district that want to sit on that board. And I think that when you look at the boards across the county, it's good to get new people in there with new ideas and to look from a different perspective. But Dean McCoy and Tim Watkins, I'm highly recommended. But we would need a motion.
Well,
Well, let me clarify. This board appointment are based on the judge's nominees and court approval. So these two have been nominated, and you would need to vote to either appoint them or not appoint them at this time.
Correct. The term expires,
Depending, if they don't, then you can come up with another nominee. If it ties, then it would hold over for 15 days, and then the judge can break the tie. I think it's 15 days.
it is. We,
I have no problem with either one of these individuals, but I would love to see Mr. Shadone stay on the board. He's did an excellent job.
And there's nothing saying that he hasn't, but I think, you know, when you get into the boards where you got people that sit on the board, it's good to have new people come in.
Mr. Shadone's only been there
Less
term.
than
Yeah.
2 years.
Is there a motion to approve or not? I'm sorry?
Could I be recognized to put some information for North Marshall Water Board?
Sure.
Mr. Shadone replaced Mr. Jerry Miller, and Mr. Shadone is just going into his second year. And I'd like to say, as being on the board now for 5 years, it takes a good 2 years to learn it completely, especially from what we came out of before. So we've really just, Mr. Shadone has really just gotten into the full scope of what the big picture is there and helping us move forward. And I did send a letter of recommendation to the judge to continue for the continuity that we presently have as well with the board and the expertise of the people that are there. Thank you.
Is there a motion not to accept the board appointments? No motion on that board appointment. We'll go to Palma-Brownsburg Fire Department Board appointment, Weldon Solomon. Need a motion for Mr. Solomon.
You're just reappointing him. Weldon Solomon, he's presently serves, willing to serve again.
Correct.
We appoint Weldon Solomon, or have him back to continue serving.
Second.
All those in favor say aye. Any opposed? Motion carries. Possum Trot Fire Department Board appoint Robert Johnson.
Robert
Motion.
Johnson's a present board member and a very good member. Make the move that we accept him to continue to serve.
Second.
All those in favor say aye. Any opposed? Motion carries. Fair Dealing Olive Fire Department Board appointment, Robert Phelps.
Yeah, Robert Phelps is on there at this time, and he said he would be happy to serve again. I move that we accept Robert on the board.
Second.
All those in favor say aye. Any opposed? Motion carries. Jonathan Creek Water District Board appointment, Jeff O'Brien.
Make a motion to appoint him.
There a second? I'll second. All those in favor say aye. Any opposed?
I know.
Vote ties. We'll wait 15 days. Move to Marshall County Cemetery Board appointments.
Judge, I'd like to explain my vote on the Jonathan Creek Water Board. As we all received, I think you did, and Bob did, and Johnny and I did.
Hang on. I want to make sure, because that was not directed to my office. That was information that was sent to all of us. And that may be information that may violate a quorum. Exactly. The information that was sent in a text to all four of us, soliciting a vote.
Was there a discussion?
There was no discussion.
All he was doing
He's
is
getting ready
tell us
to
his recommendation.
speak on that information.
Who's in it?
The board member that's,
Board member
his
asking,
term is
telling
expired.
of his willingness to serve again and their accomplishments with no discussion whatsoever.
I just want to make sure that this isn't a,
Well,
because we're,
I mean, I don't, you can't stop that from coming from the outside.
sure.
You can, as long as you address it here and there was no follow-up discussion among the group message.
We can't determine that, but we're
Well,
getting ready to take
well,
action
no, I meant.
specifically
did
on
any
that
of you
information.
respond to that message so everybody-
But I mean, he specifically refers to that message.
And I think I think if it stopped with you receiving the message and you all didn't send any electronic message to that group, did you, any of you?
No, amongst ourselves, no.
If that would have begun.
I didn't.
That's like when I send each of you an email, I usually put a disclaimer on there that if you want to respond, only respond to me and not to the group, because I don't want it to be a discussion. So, I mean, if you all received it, it'd be like you all getting a letter. And I don't think it disqualifies anybody, but as long as there wasn't discussion electronically through, but as a group, then I don't think you violated the
All right, I just want to make sure, because the typical process is, they're sent to my office.
Oh, I know.
All right, I just
And
want to
it's-
make sure.
yeah,
All I
mean,
was
and
gonna-
that needs to be the way it's done, because
Right.
if it, you know, and you can choose not to nominate that person if you want.
I wasn't going to use anything that he sent in there. I'm just going to refer, I've attended several of their board meetings, and he's a 24-year member of that board, and he's been the treasurer for many, many years of that board and very involved, and I think he's one of the glues that hold that board together through some rough times, and I would just like to see, I think he's done an excellent job. We've in that North Marshall Water Board, we have 5 out of 5 board members. We have got 3 new board members. And as we just heard Ms. Cap say, that it takes, as we all know from sitting at this table, you don't come in here and you're an expert. It takes time to learn.
At this point,
Sure. Sure.
I'm Joshua Medley. I'm current treasurer of Johnson Creek Water Board. I wanted to come here this morning not to speak to the board about the open board seat about Berry Hill. His term is up at the end of the month. I didn't come here to badmouth the board, the past boards, or the past district management. Although my words may come across this way, I assure you that's not my intentions. I've currently been a board member for a year. In that time, I've noticed a lot of problems, some small, some large. But the bulk of the problems have come from the leadership of the board. Immediately, I realized David Lovett did not run Johnson Creek Water District. Although he had the title, the district was micromanaged by the board, specifically Treasurer Berry Hill. David could not act or make a move without any approval by Mr. Hill. And that's not the job of the board. The job of the board is to give David the tools and the money that he needs to do his job. David Lovett took over as superintendent 3.5 years ago. The first obstacles he had to deal with was having to seek loans to be able to pay his electric bill. They did not have enough money in their accounts to make the electric bill that was past due and the one currently due. So they had to seek loans to manage to get by that month. They were why were they struggling to keep the lights on? The answer is simple. The district board. The bulk of the district's problems arose from the lack of financial oversight and internal controls for the handling of money. And there has been no rate change or discussion of rate change for the past 15 years. This should be on a progressive scale, with rates increasing every 2 to 3 years. Currently, Johnson Creek has some major issues coming ahead, and they should have been dealt with the past 5 to 7 years. Currently, we're 7 years behind on meter change-outs. We're an estimated 5 years behind on upgrading the meters to digital radio reads. We still currently have a girl that reads 500 meters in a single day out of 2,500 meters. That's an estimated cost of $2 to $3 million that is nowhere even near being planned for. We've got an aging pipe system in Kentucky Lake subdivision. We have preliminary engineering on that at a cost of $4.5 million. There's been absolutely no movement on that since the fall. If you mention banking or investing more money or having to go take loans out, it's totally just squashed. We have multiple water towers that need to be inspected for structural integrity. Current board members would rather just throw $250,000 to have a tower repainted, even though that tower is 30 years old and has not had structural integrity scans done on it. Never even thought to have structural scans done. Also, we've come to it's been brought to light that the Water Vision 2020 project is 30 to 40% incomplete due to the purchase of $300,000 in fire hydrants. These were fire hydrants bought because the current management and board did not care for the meters or the hydrants that they were supplied. So they went out of the scope, bought $300,000 in hydrants that they liked, and the project's not complete. And it's 30 to 40% not complete. That's gonna come back to bite us when that project is audited in 2020. Due to these past issues, we feel we could use a more current perspective with a broader range of skills on the board. With that being said, we need assistance in the finance area and more on the operational side. People that have knowledge of finances, accounting. We would like an operator to be on the board. Not technically one of our operators, but an operator that has background in the water districts. As I said, I didn't come here to talk bad about the board or its members. Barry has served for the district for 20 years, but the need for new representation with the current list of projects is going to be critical. Everything goes through PSC now. Everything goes through the state. Current board members are not equipped to deal with that. It's a changing game.
You say current board members, who are you referring to?
We have 3 older board members that have no experience with dealing with the boards or with PSC or EPA or weeding through the state stuff. I do a decent job with the mechanical part, as does Ms. Kara Wilson, and her addition has been greatly appreciated, but the direction the board needs to go is seriously hampered. And
But
it's
you're
gonna-
referring to the other 3 board members besides Ms. Wilson and yourself?
Yes.
That statement, okay.
Yes. And the direction we need to go is it's gonna cost us quite a bit of money, and we cannot do it if we're hamstrung. And it's issues that have to be addressed. Kentucky Lake subdivision has to be addressed within the next year, and that is a monster project. But that's all I have, and I appreciate your time.
Appreciate it.
All right, the position you are in at this point, you have a nominee as set out by KRS 74.020, by the county judge executive, and that is what would be on the table for a motion, that if that goes without being voted on and the position is not filled within 90 days, the Public Service Commission will make make an appointment.
PSC does?
Yep.
90 days?
90 days.
And the other is 15 days?
Well, the
For a
15
tie
days is
vote.
if you all vote and tie, then the judge can come back and break the tie in 15 days.
Yes.
My letter was penned with the assistance of everybody in our office, with the knowledge of Miss Wilson as well.
I know the Jonathan Creek area, there's a lot of concerns out there, and there's a lot of future struggles for that district. So it is going to be a challenge, but I think it's a need to get, nothing against Barry. He's been there 24 years, I believe, but we need to have somebody, different set of eyes looking at it. Marshall County, Calvert City Riverport Authority Board. I thought we did the cemetery board. Did I skip it? Marshall County Cemetery Board appointments. Marley Connor and Ethel Hendrickson reappointment.
Both presently serve on the board.
Correct.
If they'll serve, continue to serve, move that we let them do so.
Second. All those in favor say aye. Any opposed? Motion carries. Marshall County Calvert City Riverport Authority Board appointment. Andy Lyles.
Is replacing,
Don Heiss.
I'd move Andy go on the board.
Is there a second? All those in favor say aye. Any opposed?
Andy replaces Don Heiss, who passed away, which can't
Motion carries.
say enough about Don Heiss and the job that he's done, not only for Calvert City and Marshall County, but he'll be missed.
I had to work for him for several years.
He's a fine fella.
Marshall County Hospital Board appointments, there's two, their terms are expired with no reappointment. And I appoint Pamela Searles and Dr. Blake Wiseman.
Who's going off? Or they have to go off by term limits?
They have to go off.
By term limits, who are they?
Dr. Schaefer and Wendy Gibson. Is that right?
I believe so.
Replace him, I'd move it, we accept the appointment.
Second. All those in favor say aye. Any opposed? Motion carries. Code of Ethics Board appointments, Joe Frizzell and Richie Clendenin. I had a third one, but he got word that he's going to be on a national board, so he's going to be looking at something bigger and better. So I'll find a third appointment for that board.
Who are these people replacing?
There are no board members. In 2014, the 3 board members expired. It's a 4-year term, and there was no board appointments.
Are these board members staggered or?
4 years.
All of them
They
4
serve a
years?
4-year term.
Generally, the way that's been done in years past is that if there is an ethics complaint, if the board, there were any board members that weren't available, then new ones would be appointed. I mean, there's only been like, in over 20 years, maybe twice that this board has even been called together.
Well, the judge heard the recommendation from Rich Ornstein the same time Johnny and I did at CAECO Continuing Education, and he said, I can assure you that most of you that don't know anything about the ethics board, that your board was formed in 1994 when the state mandated it be done, and you probably don't have any board members, and you probably don't have, and that was the consensus, most of us present, that we did not know, but we do need to clean up that with stress, and that's good that we're doing that, and certainly got 2 fine fellows there. I have no problem with those 2.
I don't know about Brother Joel, but I think he'll be okay.
Give him a shot at
I
it.
move we approve that, make these 2 appointments to the ethics board.
Second.
All those in favor say aye. Any opposed? Motion carries. Then IT new hire.
With
He's on his way down?
Yeah, I'd like for him to make the recommendation, just so we can.
We'll move on then while he's coming down. Standing order for travel, utilities, and salaries. Did that already? She did get out of order. You want to do the treasurer's report?
Sure. May 31st, 2017, general fund had a book balance of $1,160,108.33. Road fund, $1,089,946.82. Jail fund, $74,511.92. Grant fund, 0. 911 fund, $62,096.90. Occupational tax administrator, $5,573,251.17. Veterans Van Fund, $4,068.73. ABC Fund, $81,005.50. Building Inspection Fund, $28,962.85. Total reportable funds is $8,073,952.22.
There a motion?
Move to accept the treasurer's report, subject to audit.
Second.
All those in favor say aye. Any opposed? Motion carries. We'll do, Andy, you want to update us on the new hire? We've had this position for 2 years now, and we've increased the salary. It's a very competitive position with the private sector out there competing with.
Extremely competitive. Yeah, I think that's one of the things that we found has been an issue in trying to find a candidate is somebody that's willing to work within the salary constraints that we have. But had a good conversation with a gentleman named Chad Tucker, lives nearby. He used to live in Nashville, worked in healthcare and IT in Nashville for a while, and is now back to where he grew up. So had a good conversation with him. I think he'd be a great fit. Any questions or anything else?
He meets the requirements. I know that we put out the
Yeah, he certainly does.
description.
Yeah, he certainly does.
How many years has he got in IT? I'm just curious.
Total in IT, I would say probably about 12 to
12,
13,
okay.
yeah.
All right.
Move we approve Andy's recommendation.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Thank you.
Still don't get
Treasurer's
hit by that
report.
train coming back from San Diego. Okay.
You want me to go to interfund transfer?
Instrum.
I'm
transfer,
asking
sorry.
to move $100,000 from the occupational tax administrator to the jail fund.
Motion to approve the inter-fund transfer.
Is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Appropriations transfer report.
You have a long list of transfers that cleans up most of our accounts. I'll probably have another transfer for our last fiscal quarter meeting. I do have two corrections on it towards the bottom of your first page. Membership dues, which is 01/90/100/551. I was going to move 10,350 350 out of there into the auditors. And with them, an employee vacation payout, I was gonna move 7,100 out of it into the wellness program. I wanna change those two, and I wanna move it out of 7,100,601, which is the judicial center bonds. We didn't have to make that payment this year. We'd made up 2 payments in the prior year, and there was a difference in the interest growth that allowed us to be able to waive that payment this year. So, I was gonna take it out of that $40,000. So that would take that down to $22,550.
Motion to approve the transfer.
Second.
Second.
All those in favor say aye. Any opposed? Motion carries. Approve payment of the bills.
Motion to pay the bills, Judge.
Second.
All those in favor say aye. Any opposed? Motion carries. Is there a motion to adjourn?
Motion to adjourn.
Motion to adjourn, Judge.
Favor say aye.
Aye.
Any opposed? Motion carries.